3, the purported public participation carried out by the National Assembly falls short of anything that can be deemed qualitative, quantitative, reasonable, and adequate. The National Assembly, my lords, cannot use Order 64.2 of the Standing Orders against constitutional protection of Article 10 and 118 of the Constitution of Kenya. Article 2.4 is express as to the supremacy of the Constitution in light of any other law or any other provision that is deemed to be contrary to the same. Allow me to refer you to paragraph 96 of our written submissions. And in specific, the matter in Orange Democratic Movement Party and 4 others was the Speaker of the National Assembly and 5 others, Constitutional Petition E491 of 2023 and E10 E025 of 2024 consolidated, and the rest, Your Honor. To save on time, in verbatim, the High Court held standing orders were procedural rules which guided and informed how the National Assembly should, at a minimum, conduct its business, including public participation. Standing orders did not, however, override the Constitution and were not a substitute to constitutional edit on public participation as expounded by the courts. It is therefore clear that should there be any conflict in regard to the standing orders of the National Assembly and the Constitution of Kenya is supreme. My lords, my ancestors are talking to me. My lords, paragraph 97, my lords. In Kenya National Commission on Human Rights versus Attorney General and another, 2015, 7634, the court held that the jurisdiction of the court to invalidate laws that are unconstitutional is in harmony with its duty to be the custodian of the Constitution, which promotes its supremacy at Article 2 by proclaiming at Article 2.4 that any law, including customary law, that is inconsistent with the Constitution is void to the extent of its inconsistency. And any act or omission in contravention of this Constitution is therefore to be deemed invalid. My lords, Article 150, as read with Article 145 of the Constitution of Kenya, does not expressly limit the time within which a resolution for impeachment must be arrived at or concluded. Standing Order 64.2 therefore lacks constitutional bearing and is subject to judicial review by this esteemed bench. Its constitutionality must be examined under Articles 2.4, Article 165, 3D of the Constitution that gives this bench the authority and the jurisdiction to interpret the same. My lords, it is my submission that demonstrably public participation purported to have been carried by the National Assembly is, for want of a better word, a shambolic affair. It was a display of the fallible nature of our attempt at democracy as a nation, and if the apparent manner in which it should have been conducted was clear and loud from Justice Mungo's orders, perhaps then the prevailing circumstances of a premeditated, politically instigated process, it could have fallen or the orders of Justice Mongo could have fallen on deaf ears. With no shield under Order 64-2, the National Assembly is therefore exposed for what it exhibited as a lawmaking body that does not obey the law. This must result in an outcome that cannot stand in a constitutional democracy governed by the rule of law. Allow me to refer you to paragraph 33 of our submissions in the matter of Mark Foy versus United Africa Company Limited, 1961, 3 ER 1169. The very famous Lord Denning, who was as classic as the good professor of law, Gideon Wegai, held that if an act is void, then it is in law and nullity. It is not only bad, but incurably bad. You cannot put something on nothing and expect it to stay there. It will collapse. Any subsequent actions undertaken by the National Assembly based on the null and void acts of the purported public participation must therefore collapse. They cannot hold in law. Blatant disobedience of the court orders must be rendered null and void ab initio. My lords, my lady, I think I've kept my time. As the Latin maxim goes, fiat justitia ruat caelum, and for the benefit of our lay friends, let justice be done though the heavens fall. My lords, I will not proceed beyond that. And, the good Senator Agenda was muttering something when I said that I have my sisters, my learned sisters here. Yes, they're my sisters, Senator, but they're not available. Thank you, my lord. I hand over to my colleague, Mr. Muge.
Thank you. You are smart on time. We hope that subsequent parties will observe that trend which has been set. You asked for?
I had asked for, in total we're supposed to have 1 hour. She's taken about 10 minutes, I think. 25 minutes. I'm going to take a much shorter time. I have agreed with my senior, Mr. Kibe, that I will be not donating 30 minutes to him.
Okay.
So, my lords and my lady, I proceed after my learned colleague, Ms. Minor, and I am in the unfortunate situation where the gravamen of our petition was public participation, and my lords, my colleagues before me have covered this subject quite deeply. So instead, I will essentially head into the nitty-gritty of what will be provided to you, has already been filed in court and will be provided to you by the respondents as proof of the exercise of public participation. My lords, as I considered these submissions, I was reminded of a phrase, rather a prayer, from my alma mater, Lenana School. And the prayer says, my lords and my lady, sieve the trash, dear Lord, we ask, for nihil praeter optimum. Nothing but the best. My lords, in regard to public participation, the intentment of the Constitution and of the citizens of Kenya when we promulgated the Constitution was that public participation must follow a process that produces nothing but the best. My lords, in that respect, there is a concept in computer science called GIGO. Essentially what it says is rubbish in, garbage out, GIGO. Also termed as RIRO, rubbish in, rubbish out. This is in regard to processes, and any process, my lords and my lady, that is expects to have an output is highly dependent on the quality of the input, the quality of the process itself, and that will determine what the eventual output is going to be. So, my lords, keeping in mind this concept, GIGO, and the expectation pronounced and enunciated in BAT, I will not repeat all these authorities that have been placed before you. The components enunciated in BAT, I would like to now, my lords, walk through each of the documents that will be placed before you. And we start with the Gazette notices that were published on 2nd of October. The Gazette notices were published on 2nd of October, 3rd of October. These are the advertisements. 2nd of October, 3rd of October, 4th of October, and finally on 5th of October. My lords, this will be, you will find this in the affidavits, in the annexures to the affidavits of Mr. James Njoroge for the second, Mr. Samuel Njoroge for the 2nd and 7th respondents. Now, the first advertisement that was placed on 2nd of October, my lord, there was already an issue without advertisement. Why? Because one of the very first expectation under the components of in BAT is reasonable notice. This advertisement was placed on 2nd, notifying Kenyans that there's going to be public participation 2 days later. When Justice Mwongo on 3rd of October issued his order, he had taken into consideration the fact that 2 days was simply not enough, and he needed and directed that there must be more time given to the Kenyan public. 2 days. But my lord, looking at that advertisement, what was it actually doing? One, it provided venues, 47 venues. And this is important because what happened after that in regard to the advertisement issued on 3rd and advertisement issued on 4th were all amendments of the advertisement issued on 2nd. Now, already 2 days, 48 hours for public participation. My lords, we have been told, and you will be told by the respondents, that the reason that they decided to take just 2 days for public participation is because the Constitution provided that impeachment of the Deputy President is time-bound. And in regard to that, they will point to Standing Order 64-2, showing that Standing Order 64-2 requires just 7 days, and the exercise must be completed in 7 days, the whole impeachment exercise. And that is the reason they provide for using just 2 days for public participation. But my lords, when you look at Article 145 on timelines, you will note that the timeline, there is no restriction at all on public participation, on the time between the motion being moved and a resolution being passed. The time between a motion being moved and a resolution being passed, no time is limited. Limitation starts from when the resolution has been passed. That is the only time constitutional timelines kick in. So the reasons provided for limiting impeachment to 7 days and therefore curtailing the provisions of Article 10 and Article 118 do not exist in regard to public participation. My lords, as I had previously stated, the second advertisement was put out on 3rd of October 2024. That Gazette notice made one change. It changed the venue for all the Kenyans participating in Nairobi, from KICC to Bomas of Kenya. My lord, so what now has happened is that all the residents of Nairobi, based on an advertisement placed on 3rd for public participation on 4th to happen at Bomas of Kenya, have only 1 day. 2 days, my lord and my lady, was already limited. Now we have an advertisement of a different venue, 1 day. If 2 days was bad, 1 day is terrible. Then, my lords, on the same day, the day scheduled for public participation, a gazette and another advertisement was issued. This time, 20 counties, 20 constituencies, pardon me, 20 constituencies had their venues changed. These were constituencies in Bungoma, constituencies in Nakuru, and constituencies in Meru. 20 constituencies being advertised and the citizens being told, you will undertake public participation today, and these are the venues. These are people traveling from all corners of these constituencies now being shifted and told public participation is today, you have 1 day notice. No, this time around you have 0 day notice. Public participation is today. 2 days was already bad enough. 1 day was terrible. 0 day notice was horrible. In regard, my lords, to the orders issued by Justice Mongo for public participation as a second stage. My lords, the orders of the learned judge were very clear. He stated that he would allow public participation to continue on 4th of October as the first stage, a stage. And he mandated, ordered, that there shall be a second stage of public participation created as a new public participation exercise in keeping with all the components in BAT. Proper notice, not the 2 day notice. proper information, not the lack of information provided in the Gazette notices, proper structures, proper access, and most importantly as a base, proper sensitization. What happened instead, my lords and my lady? On 4th at 10:22 p.m. and at 10:44 p.m., the clerk of the National Assembly drafted a press release, and that same press release was published in the, I think it was in the Nation and the Standard. That press release, my lords and my lady, was for extension, my lord, of the first stage, not a new stage. If you look at the affidavit of Jen Jeremiah, that would be in JNM2. If I can find it, 1 second. This advertisement is on page 14 of the annexures to JNM2. It reads, notification of extension of public participation. My Lord, purportedly in compliance with the orders of the Honorable Justice Mwongo, the clerk of the National Assembly decided, no, we will not do a repeat exercise. We will simply add 1 day to the exercise that is already ongoing, which the Honorable Court already has issues with and has issued directions in regard to, and instead we will just extend it. And what does this Gazette, this advertisement do, my lords? It does not, this time round, even bother to provide the grounds in which the motion seeks. It does not bother to include pullouts. It does not bother to make any attempt to provide any information, and simply makes the assumption that anybody that this advertisement is directed at will know what to do. It does not provide any venues and simply states there will be public participation at the constituency level. In the first, second, and third advertisements, there were 47 venues for the counties, specific venues. For example, Tononoka Social Hall for Mombasa, Kwale Cultural Center. They were very specific. But for the 290 constituencies, absolutely nothing. My lords, to compound the problem, the clerk and the National Assembly were clear in their minds that what would be required by the public in regard to sensitization and information should be provided. So what do they do? At the bottom of the advertisement, they provide a link to what they call the template. It is a link, and this is to the template. But at the bottom, in regard to the notice of motion, any evidence, and all the documents that they rely on, they provide at paragraph 5 of that advertisement that copies, and I read verbatim, copies of the special motion stating the grounds for removal and particulars of the allegations, together with the relevant documents, may be downloaded from the Parliament website. That is all. Telling Kenyans that you are invited to participate in this impeachment process, the evidence that you need to look at, the grounds that you need to look at, all the information that you require is on some website. We know that you will need this information, but you go look for it yourselves. It does not say that we will provide the information for you at the venues, and no proof has been filed in court to show that at any of the venues where public participation took place were the notice of motion and all documents pertaining and all particulars ever provided at the venues. That, my lord, is the failure of the Gazette notice itself. Then, my lords, if we look at the pullouts, what has been termed as the template, you will find one of the pullouts. If you look at, if we look at page 235 of the annexures filed on behalf of the 2nd and 7th respondents, again in the affidavit of Mr. Njoroge. I will be speaking to the affidavits in these, the annexures in this particular affidavit. My lord, if you look at this template, what is being called a template? It is purportedly a template to collect views. A template to collect views. My lords, from our understanding of what a template is supposed to be, is that somebody will take a template and then convert it for specific use. This is no template. My lords, if you look at it, it is nothing but a ballot paper. This ballot paper, being called a template, asks the people who will use it to make an election on a specific motion and on specific grounds, 11 of them. Paragraph 6 of this ballot, my lords, asks what are your views on the motion, and tick what is your vote. It is not a view. Do you support? Do you not support? And other specify. This is a ballot question. It is not a view. Each of the 7 grounds provided from paragraph number 7 does exactly the same thing for each of the grounds. For the grounds themselves, no information is provided that could help my grandmother in Kimoro village, Nandi County, to understand what gross violation of Article 10(2)(a) is. It is an absolute impossibility. If she was to make that tick, it would not be based on any information. Why? She was never sensitized. She would not understand what she is taking in this ballot. And we will keep insisting that it is a ballot. My lords and my lady, and it is important that we note, at the end of this ballot paper is a date, and that date is important because there was a reported public participation exercise on 4th of October and another on the 5th of October. So we assume that for every form that was returned, it was signed and there was a date. There was a batch for 4th of October and there was a separate batch for 8th of October. And this will become important when we move to the report from Parliament on public participation. My Lord, I would like to make a note on the public announcement on 2nd made by Parliament on their social media. You will find it at page 239 and 240 of the annexures of Mr. Njoroge. And it shows that on page 239 that what they called as notification to the public received 125 comments, 19 shares, 203 likes. The penetration was close to 0. On page 240, I guess they decided to clip that out. Did not want to show it. So then, my lords, we've walked through the process itself on public notice and the template, the ballot paper that was used to gather views. So then, my lords, we move to the report itself. This report is a report that is supposed to show that indeed there was public participation that occurred. The bulk of the report that has been filed in court is pictures from 290 counties. And those pictures, I think, begin from page 296 of the affidavits that I refer to, Njoroge, and starts with the pictures and information from Ainapkwe constituency. And this, my lords, is where it becomes clear on what this exercise really was. For Ainapkwe constituency, at paragraph 61 of this report, it states that the public participation exercise took place at Ainapkwe NGCDP office. A total of 959 members of the public took part in the exercise. Of this, 808 persons indicated that they supported the motion, while 133 persons did not support the motion. Further, 18 persons expressed other views with regard to the special motion. Obviously, my lords and my lady, I did not belabor the point, but 808 persons indicating that they support is a vote. It is not a submission. But what is more telling is that the public participation exercise took place at Ainapkwe NGCDP office. You were not told when this happened. Was it on 4th? Because if it was on 4th, there was definitely no public participation at Ainapkwe. Was it on 5th? There is a possibility it would have been on 5th. But we are not told. From the report that you will see at table 2, actually table 3, of the National Assembly data, that table starts from page 436 of the annexures, which is a combined tally of all constituencies. You hear absolutely nothing about views collected at KICC, views collected at Bomas of Kenya, views collected in any of the 47 venues. All you will read is from number 1, Ainapkoi constituency, 970. Ainamoi, 756. On and on until the very last one, with the total being shown here, being 224,877 votes. None of them tell you when these views were collected. And this is the only evidence placed before you to show that public participation took place. A table that is unverifiable. A table that is unreliable. And my lords, this unreliability is deeper than just these numbers shown on this table. There were 11 grounds. You have not been told or shown how many people supported ground 1. Gross violation of Article 10 2A(b). Of the people that supported the motion, if they actually understood what they were doing, how many people supported ground 1? That information is not provided. We say because the information is not available. If it was, it would be before you. How many people supported ground 2 on Article 147? How many people supported any of the 11 grounds? My lords, you're not told this. Yet this is supposed to be the result of public participation in an impeachment process, and all you have received is ballot numbers, a count, no views at all. You are not told that in Ainapkoi we had discussion and were submissions, and 1 or 2 people, or none, stood up and said something. Absolutely nothing. My lords, those pictures that you will see show absolutely nothing but an election in makeshift ballot offices. My lord, if you look at page of the report again, going back to the report, and this should, page 286 of the report, consider this statement made at paragraph 58, page 286. It reads, and I need to repeat this, read this verbatim. At the close of the period for public participation as extended, a total of 38,065 submissions were received. And at A, via email, 7,106 submissions were made. Hand delivered, 30,955. My lords, public participation ended approximately, let's say, 5 p.m. on 4th. Same time on 5th. Somehow, my lords and my lady, and this should make it clear that the information being provided to you is garbage. 30,000 Kenyans somehow walked into the National Assembly to deliver submissions to the clerk. My lords, even if each of these 30,000 Kenyans took 1 minute, just 1 minute, that would be 30,000 minutes. That is how long it would take. 30,000 minutes. Even with multiple clerks handling, it would be a total of 7 days to process that kind of bulk input. The only inference that can be drawn from these numbers, 30,955, it is fiction, as the rest of the tables are absolute fiction. My lords, from those numbers, from that information, it is clear that all we had was a count, a ballot, and unverifiable at that. So what is supposed to have happened with this information, if indeed it was public participation and should have been considered by the National Assembly? I will direct you, my lords, to the Hansard, which is from page 1078. That's the Hansard starting in the morning at 9:15 a.m. for the morning session, and from page 1137 to starting at 2:30 p.m. My lords, I've made a summary because this is approximately 160 pages, and I'm sure you would not want me to walk through each of those pages. So instead, this summary, or rather the Hansard, provides the proof that even if something happened out there, the purpose of public participation should be that Parliament will consider the views of the public. Even if they disagree in the end, they must be considered. What did Parliament do? What actually happened in Parliament? My lords and my lady, at about 9:30 a.m. on 8th of October, the Honorable Millie Odhiambo tabled the report, the public participation report. This is the first time it has moved from committee, coming to Parliament for consumption. It is tabled at 9:30. My lords and my lady, what happens immediately after that? The motion is moved, and away we go. The report has not been considered. Debate, the motion is moved, debate starts immediately. The Honorable Millie Odhiambo is advised that she would have 15 minutes sometime during the day to speak to the report of the Committee on Public Participation. By the time she gets to speak to that report, 21 members of Parliament have already spoken without having had anything. In the afternoon, all the other members of Parliament, the honorable members, participate, and in total, the participation from them is 66 members speak, either in support or in opposition. And as you can see, the petitioner is at number 58 of that graph, and she opposes. But the damning evidence from this summary, and the whole Hansard, my lord and my lady, is that of all 66 members that participate, all 66, only nine members mention public participation or the views from their constituents. A whole day. Not any mention of the views from Mombasa County, from Kakamega County. Nothing. And the reason being, and it is rather obvious, that report sat on the table of Parliament with nobody touching it. Nobody looked at it. Nobody knew what its contents were. They had absolutely no opportunity to participate with it. My lords, I would like to leave it there. But in the end, if there ever was this exercise is a dead ringer for the concept of GIGO, garbage in, garbage out. My colleague, Mr. Nderitu, will handle the prayers. And as I said before, I donate my 30 minutes to Mr. Kibi.
We took 40 minutes. How much time will you take?
Just 2 minutes, my lord.
2?
Yes.
Oh, proceed.
Or even less. My lords, my lady, my name is Benan Nderitu. I shall be submitting on the reliefs sought on behalf of the third petitioner. Relief number 1. Your lordships, we are seeking a declaration from this court that the impeachment process conducted under Standing Order 64-2 violated the Articles 118, 145, 47, 50, and 10 of the Constitution. Relief number 2. Your lordships, we are seeking a declaration from the court that the modalities placed by the first respondent in respect to the public participation forums of 4th October 2024 fell below the threshold of proper, effective, and meaningful public participation as envisioned under Article 10 of the Constitution. 3, we are seeking that the modalities placed in regards to the public participation held on 4th and 5th October were in disregard of the court order issued in Kirogoya in petition E014 or 2024. 4, we are seeking a declaration that the public participation held on 4th and 5th October 2024 did not meet the constitutional standards under Article 118 of the Constitution. 5, we are seeking a declaration that the Senate violated Article 118 of the Constitution by failing to conduct public participation. 6, we are seeking a declaration that the impeachment process undertaken by the first and third respondent in view of the public participations held on 4th and 5th October fell below the threshold and therefore unconstitutional, null and void. This in regards to Article 10 of the Constitution. 7, we are seeking a declaration that the appointment of a select committee by the Senate is mandatory in the impeachment process of a president and a deputy president. 8, the proceedings in regards to the impeachment process outside the select committee were unconstitutional. 9, we are seeking a declaration from the court that the Standing Order 64-2 should be declared unconstitutional to the extent that it provides timelines which are not compatible with the constitutional requirements. 10, we are seeking an order of certiorari quashing the National Assembly resolution of October 8th, 2024. 11, we are seeking an order of certiorari quashing the Senate resolution of October 17th, 2024. And last of the reliefs, your lordships and my lady, we are seeking is costs to the third petitioner. I humbly submit. Thank you.
Thank you.
My lords and my lady, if it pleases you again, my name is Wamboi, Shadrach Wamboi. I appear on behalf of the 9th petitioner. My lord, what is before you is our amended petition dated the 28th day of October 2024. It is supported by an affidavit sworn by Ms. Dorcas Mwai, dated the 29th day of October 2024. My lord, further to that, and in support of my arguments or our arguments, we have filed submissions and a list of authorities, both dated the 27th day of April 2026. And my lords and my lady, on our part, we will wholly seek to rely on our written submissions and the factual matrix that has been set by the deponent of the affidavit sworn in support of the amended petition. My lords and my lady, if you permit me, just briefly to highlight. My lord, the 9th petitioner being a public benefit organization, thank you. My lord, the 9th petitioner being a public benefit organization and speaking on behalf of the public indeed appreciates the opportunity granted by these proceedings, at the very least, to ensure that the impeachment process that was conducted leading to the removal from office of the first petitioner, His Excellency Rigathi Gachagua, from office, is one that is solely and not a political process, but is one that is a sui generis constitutional process that primarily is legal, though characterized by politics. Away from the political characteristic of an impeachment process, my lords, our duty as the 9th petitioner is to persuade you to making a finding that the process, as we witnessed on the 9th day of October 2024, together with the events of the 17th day of October 2024, leading to a resolution of the Senate to have the Deputy President, the former Deputy President, impeached from office, was done in haste, was done contra-constitutional. And my lord, as I shall demonstrate, the Senate, in our very humble view, appears to have walked over the very provisions of Article 145 of the Constitution. My lord, my arguments will be split into two. Firstly, I will wish to draw the attention of the court to the Hansard proceedings of the 9th day of October in an attempt to demonstrate to the court that the facts provoking the petition before court are not in dispute. It is not in dispute that the Senate, having had an opportunity of considering whether the motion for the removal of the Deputy President will be considered at the plenary or by an 11-member committee, opted in their wisdom to have the motion considered by the plenary. My Lord, to that extent, the question that the petitioner will be urging the Honorable Court to consider is whether the very dictates or the authority that flows from a reading of Article 145(3) of the Constitution permitted the Senate to have an option on whether the matter should be decided by the plenary or the matter by the constitutional dictate ought then to have been considered by the 11-member committee. My Lord, I make reference, express reference to Article 145(3), particularly 145(3)(b), where the Constitution dictates that the Senate by resolution may appoint a special committee comprising of 11 of its members to investigate the matter. My Lord, while the word may be interpreted to mean that the Senate had the discretion of opting to have the matter deliberated by the plenary or by the 11-member of committee, the position that we humbly hold with respect, my lady and my lords, is that regardless of the word may, the Constitution so demanded that the Senate proceed to have the matter heard and determined by a select committee or a special committee of 11 as opposed to having the matter decided in the plenary. My Lord, my persuasion or our persuasion to move the Honorable Court to making a finding that the use of the word may in this instant have given a command to the Senate to have this matter decided by the special committee is informed by the growing jurisprudence within the Republic of Kenya. Particularly, my Lord, I will wish to make reference to the Court of Appeal decision made in the year 2023, Civil Appeal, my Lord, number 3 of 2023. This is the case between the National Assembly and another versus Okia, Okoiti, Omtata, and 55 others. My Lords, with humility, I will wish to draw your attention to paragraph 145. Paragraph 145 of the said authority, where, my Lords, borrowing from the jurisprudence that has been set by the Supreme Court of India, are noted that it is settled that the word may is capable of meaning must or shall in light of the context, and that where a discretion is conferred upon a public authority coupled with an obligation, the word may, which denotes discretion, should be construed to mean a command. And my Lord, this Honorable Court has an easy task of interpreting the Constitution, because the very same document that you are called upon to interpret has already, under Article 259, given us modalities through which this Constitution should be interpreted. It should be interpreted in a manner that the Constitution is always speaking. So much so that by any reading or interpretation of the Constitution, then the Constitution should not be read to be speaking to us in a way that causes confusion in our interpretation, but in a manner that guarantees us clarity, in a manner that promotes the very values and principles of the Constitution and the human rights and fundamental freedoms of the person aggrieved. My Lord, going under or going down the reading of Article 145, is that there are certain safeguards that have been put by the framers of the Constitution to ensure that a party, in this case, either a president or a deputy president facing the motion of impeachment, enjoy certain safeguards to ensure that his right or her right to a fair trial is not run over. And this is by ensuring that the special committee, this is particularly Article 145(4), the special committee is mandated by law, by the use of the word shall, to investigate and prepare a report presented within 10 days on the particulars, if at all, the particulars of the allegations, if at all they have been proved or not proved. The writing of this report, and we submit with humility, is to ensure that two fundamental things are done. First is that the other members of the Senate are properly informed of the allegations that have been substantiated. And secondly, to grant an opportunity to the deputy president or the president who is facing an impeachment motion, the opportunity of understanding in full flavor the accusations that have since been substantiated, to permit them the opportunity of answering substantively to all the questions that have been, or all the allegations that have been made against them. In this case, as it were, when the Senate on the 9th day of October 2024 decided to interpret Article 145(3) in a manner that gives them the discretion of choosing or opting on whether the matter should be heard by the special committee or the plenary, it means that they indeed substituted the place of the special committee with the Senate committee, or the Senate sitting together as a committee. This, in other words, would mean that if, assuming for argument's sake, that the court is to make an inference that the word may, in this case, was or did give them the discretion of choosing, then it therefore means that a very crucial step that is required under law was missed by the Senate at the point of deciding that the former Deputy President, His Excellency Rigathi Gachagua, should be impeached from office. And this step, my lords and my lady, is that of tabling a report for the purpose of furnishing the respondent with sufficient notice on the allegations that have been substantiated. So, my lord and my lady, the argument that we make is that to the extent, my lord, that the plenary or other members of the Senate proceeded to hold that 5 out of the 11 grounds had been substantiated without affording the first petitioner an opportunity of answering to the grounds that had been substantiated. That in itself meant that a crucial step dictated under Article 145 of the Constitution was missed. My lord, as I mentioned earlier, that the reading of the Constitution as a document that is always speaking to us should be taken to be speaking to us with clarity. This is to mean that if we are to assume that the word may, as indicated under Article 145(3), does not place an obligation on the Senate to form a special committee, then it therefore means that, as it were, and as we find ourselves in, we get ourselves confused, because one would wonder if, in the absence of this special committee, why will the Senate then be writing a report to itself? If we are just to allow the interpretation as was made of this article by the Senate to succeed, why then would we permit or allow a situation like that to succeed? My lords and my lady, your brothers and sister at the Court of Appeal, over and above borrowing the jurisprudence of from the Supreme Court of India, had the following to say, and they noted that the court, as this court is called upon, has a duty to examine the scheme of the Constitution, the purpose and the object underlying the provision, and with emphasis, my lords and my lady, the consequences likely to ensue if the provision is interpreted one way or the other. So that, my lord, as you retire to the privacy of your chambers to write a reasoned judgment on this issue, we pray with humility that you return a finding that indeed, for the sake of posterity, it is indeed incumbent on the Senate under Article 145.3 to, by law, establish, when invited, a special committee to consider whether the allegations made by the National Assembly or the mover of the motion by the National Assembly, in this case, the Honorable Mutuse, was, number one, investigated, number two, whether there was substance in the motion for the removal of the first petitioner before the Honorable Court. So, my lords, without saying much, I will yield the floor to my colleague, Ms. Waithera, to also highlight a few issues that I may have missed out. That is all from me, my lords and my lady. Thank you.
Thank you.
If it pleases my lords and my lady, my name is Wanjiko Waithera for the 9th petitioner. I will take over from where my senior and colleague has left out. My lords and my lady, Article 259 of the Constitution is the bedrock of constitutional interpretation, and it requires that the Constitution shall be interpreted in a manner that promotes its purpose, values, principles, and advances the rule of law, and human rights and fundamental freedoms of the Bill of Rights. Further, it shall permit the development of the law and contribute to good governance. My lords and my lady, relying on the Court of Appeal decision of the Attorney General versus the Law Society of Kenya, 2019, the court emphasized that the principles of, that in interpreting the Constitution, we have to look at the holistic interpretation of the Constitution, such that the various chapters and articles of the Constitution are read as one document and not as disjointed sections where each provision is destroying the other. Further, the court noted that all provisions have to ultimately be in harmonious symphony. The Supreme Court, in the decision of the Kenya National Commission on Human Rights 2014 EKLR, defined the meaning of what holistic interpretation of the Constitution is. And the court noted that the Constitution has to be taken in context. It is the contextual analysis of the Constitution, reading it alongside and against other provisions, so as to maintain a rational explication of the Constitution, meaning that the history of the articles has to be taken into consideration. My lord and my lady, we have raised two substantial issues in the impeachment process. And the first one is whether the nomination of the deputy president can be legally finalized or approved in absence of a fully constituted IEBC. Taking a reading of Articles 82 of the Constitution together with Article 88, which enumerate the functions of the IEBC to include regulation of the process by which parties nominate candidates for election and monitoring compliance relating to nominations of candidates. My lords and my lady, the two provisions, and by extension the IEBC, provides electoral oversight and approval of candidates for nomination. It is not in dispute that at the time when the second interested party, Honorable Professor Kithure Kindiki, was nominated for the position of the deputy president, there was no properly constituted IEBC, with various commissioners having either resigned or retired. The Supreme Court recently, in the decision of IEBC versus AG, an advisory opinion 2025, sought to draw a clear distinction on what the administrative roles of the Secretariat and constitutional mandate of the IEBC ought to be. And the court noted that it is our considered view that the exercise of constitutional functions expressly reserved for the Commission, such as those enumerated under Article 88(4) of the Constitution, cannot be lawfully discharged in absence of a properly constituted commission with the requisite quorum as contemplated under Article 251 and 252 of the Constitution. My lords and my ladies, it is our humble submission that the nomination of the second interested party ran afoul the provisions of Article 88 as read with the 82 of the Constitution. We submit that the principles that the court articulated that the commission must be properly constituted cannot have been discharged in order for the IEBC to discharge its mandate, has to be held in equal, if not greater, force when it comes to approval of the second highest position in the executive of the Republic of this country. My lords and my ladies, the second issue that I seek to persuade you is whether the nomination of the second interested party, while serving as a cabinet secretary, violated provisions under Article 148 as read together with Article 137 of the Constitution. It is not in doubt that at the time of nomination and even approval of his role as to take over the role of the deputy president, Honorable Professor Kithure Kindiki was serving the people of the Republic of Kenya as a cabinet secretary for Interior. My lord, by its definition, a state officer under Article 260 of the Constitution includes persons holding the position of cabinet secretary. He had neither resigned from this position at the time when Parliament approved his nomination. My lord, Article 149 of the Constitution cannot be read in isolation. It has to be read together with Article 137, 2B, and 148, 1. And the only exception that the Constitution provides for persons who can be nominated for the presidential position are people who are already serving as a president, a deputy president, or a member of public. None of these positions, the second interested party was not serving any of these positions. And therefore, we humbly submit that a person who already holds a position of cabinet secretary at a time of nomination as a deputy president does not satisfy the constitutional qualification set out in Article 137(2)(b) as applied through 148. And therefore, the nomination of the Honorable Professor Kithure Kindiki runs averse the said provisions. My lords and my ladies, via our petition, that is petition number 565 of 2024, we had sought the following reliefs. The first one is a declaration be and is hereby issued that the rights and fundamental freedoms of the first petitioner, including his rights and freedoms under Article 25C, 50, 27, 47, and 145, were grossly violated by the third respondent on the 17th day of October by declining to allow him an opportunity to adjourn and be heard during the sitting of his removal by way of impeachment. The second relief we have sought is that a declaration be and is hereby issued that the decision by the third respondent to have the first petitioner removed from office by way of impeachment, to the extent that it was done in gross violation of Article 25, 50, 27, 47, and 145, 5, is unconstitutional and null ab initio. A declaration that subsequent replacement of the first petitioner to the office of the deputy president was also unconstitutional. We've also sought a judicial review of order of certiorari to bring to this court for purposes of quashing the Gazette notice by the third respondent dated the 17th of October, communicating the removal from office of the deputy president of the deputy president by way of impeachment. A judicial review of certiorari does hereby issue to bring to this court for purpose of quashing the decision of nominating Professor Kithure Kindiki as the deputy president of the Republic of Kenya for failing to meet the qualification under Article 137(2)(b) and 3 of the Constitution. In the alternative to that fifth prayer, we have sought that the Honorable Court does make a declaration that the appointment of the Deputy President to fill vacancy arising from the removal of the first petitioner from office pursuant to Article 149 of the Constitution must be read together with Articles 82 and 88 of the Constitution to give the IEBC its constitutional mandate of approving the name of the nominee as proposed under Article 149 of the Constitution. We have also sought a declaration be made that the approval of Professor Kindiki or any other person as the Deputy President of the Republic of Kenya is subject to Articles 82, 88, and 137 of the Constitution. We've equally sought cost of this petition. My lords and my ladies, I have refrained from regurgitating what fellow counsels for the petitioners highlighted in respect to the impeachment processes and the violations that we witnessed therein, including public participation and the violation of the right to be heard by the first petitioner. All those are contained in our submissions. That is all, my lords and my ladies.
Thank you.
If it may please you, your lordships.
It's me, I don't know.
You know, I remember Mr. Kibe had said that for us who had booked 10, 20 minutes, we can go ahead because he has a long time. I believe that is what when we spoke.
We are following the order, and I'm next. You are 58.
It's okay, you can take the floor.
If it may please, my lords and my lady, the appearances for the 10th to 41st petitioners are as previously indicated. For purposes of the order of submissions, my lord, I'll take about 1 hour, 15 minutes. My learned colleagues, Mr. Martin Kamwaro, has indicated he needs about 25, 30 minutes. And then Mr. Peter Koira, he will take about 10 minutes. So if we could start right away, I think the first thing is our submissions have been furnished to the court alongside a book that we thought it is easier to give the book by law monthly because of what it covers. We thought it is easier to give it as a book. I've given Professor Muigai and Senior Counsel Paul Muite. So, be that as it may, we shall be referring to those submissions. The rest of the advocates we are annexing in our submissions. Yes, relax. The relevant passages of the book are in the submissions. Now, my lords, for purposes of taking the process forward, I think the first thing we want...
These documents, these books,
yes.
Are they given as part of the court record or given to us as individuals?
Part of the record. We have referred to those books.
Part of the court record?
Part of the court records, yes.
And then after that?
You can keep or donate.
Okay.
It's part of the record. I could have photocopied it, but it was going to take a little bit longer. We have been running short of time. But we have referred to it extensively. The parts that are relevant have been referred to in our submissions.
All right.
My lords, be that as it may.
My lord, with your very kind permission, I would really not have wished to interfere with my learned senior friend, Mr. Kibe Muge, but just the same concern that the court is raising. We've just been served with these written submissions. Whereas we don't have a problem with going through them quickly and getting to follow what Mr. Kibe Muge will be saying, he says there's also, in addition to this, a book that he'll be referring to. It is expected that after he's done, we'll be taking the stage. We've not seen this book. I think just one copy has been given to Professor Gibbel. It would only be fair that we have access to all these documents so that when he's done, at least we'll have had an opportunity to look at what he'll be making his submissions on.
We have referred the 3 passages from the book. I can direct him to the paragraphs where the book is referred to.
I think it's only fair that we get copies, so that then we don't get into a situation where...
I can't afford to give everybody a copy.
He can't then choose to come to court and say, I'll give this book to certain people, certain parties, and not others. That cannot honestly be.
I think to save time, Mr. Mugai, you can just detail somebody to get copies.
Yes,
yes, so that we can
Thank
proceed.
you, my lord. We shall get them
of the relevant pages.
Yes.
Of the relevant pages.
Actually, they are cited. They are just 3 passages that are cited. The rest is for somebody who wants to read the broader picture. Just like Hamilton's Federalist number 65 has been quoted a single passage, but anybody can read the entire Federalist 65. So it's a simple issue, really. I hope this cannot distract me, so I can proceed. And just for the record, I had spoken to my learned colleague, Mr. Professor Ojienda, Senior Counsel, and we reached an MOU that any points of information and points of order to be spared from me for today. So I hope I can make my presentation as quickly
My
as
Lord,
it
I
goes.
think this matter is not being given the seriousness it deserves. Mr. Kibe Mugai told you that book is part of the record, which means the entirety of the book has been filed. Unless it is on CTS, and unless every party has been given a copy, whether in original or in photocopy, it cannot be part of the record. And it cannot be done to say, I looked through the bar, I saw some people, because they are professors or they have this teacher, I have decided those few are the ones I'll give a book he wants to be on the record. A book we might never even have the time to cross-check, so it cannot be on the record. And we are not raising this as a frivolous point. That's just not how we do business. It has never been done that since the birth of the common law, 1076 AD. It is litigation. You want material record, every party must have a copy of that material. Thank you, my lord.
Why don't you then wait for him to set the background, and if he makes any references which you are not satisfied with, then you raise an objection? Because at this stage, I don't know where this book comes in.
You see, my lord, the problem I have is these proceedings may not end here. So if that book is part of the record and we don't have it, when the record of appeal for the next level is prepared, when the court ceases to consider that material, that's what I'm saying, it means something to say that a document is part of the court record. What I would have had him to say if he was doing this thing properly is he would have told you, I am seeking leave from you to put this material on the record, and I will serve it on all the council and all the parties, because that's how things are done.
I think I heard your lordships, the presiding judge, saying that we should photocopy the book and avail everybody, and that is being done, and the book is already referred to in our submissions and in our list of authorities. So I don't know whether this should be said in all local languages or sufficient that one is enough, because you have already given a direction.
I think, Mr. Mugwai, what you need to do is to avail the specific pages you have referred to.
Actually, I'll photocopy all of it and upload. That is the only thing remaining. My assistant Sylvia is here. She's organizing for that to be done. So before, and we shall start with serving Mr. Mudomi. Actually, his copy should be brought. So we shall bring all these issues to court. There is no big deal. You've given the directions. We photocopy the book. It's a small book. We shall photocopy. Sylvia is already doing it.
Proceed, please.
Yes, thank you, my lord. My lord, as I've indicated, the pleadings in this matter have been referred to. This is a very small space, so we may not have any time to refer to pleadings. Huh? So the pleadings, they are in my bag there. So the pleadings are referred to in paragraph 2 of our submissions. This is at page number 5. Having now said that, I think the next important things to say is who are the 10th to 41st petitioners. My lords, petitioners number 10 to 40 are public-spirited Kenyans, but more importantly, they describe themselves as part of the political constituency of the first petitioner in this matter. This is an impeachment, and impeachment from the High Court, Court of Appeal to the Supreme Court. We've had passages in the judgment saying it is a political process and it concerns political matters. They are the part of that constituency. The 41st petitioner, Gemawado Association, is an association of lawyers from Mount Kenya region who are over 1,000 and who are also part of this petitioner to try to seek justice with regard to the impeachment that occurred against the first petitioner. Having said that, my lord, I wish to say that it is my great privilege to appear before a 3-judge bench of the High Court under the 2010 Constitution. I believe that matters. I had an occasion previously to appear before similar benches, but under the old constitution. So why does it matter that we are appearing under the current 2010 constitutions? My lords, as we have argued in our submissions, it matters a lot that justice in this case is required to be administered in accordance with the 2010 constitutions. Because this constitution does three things. These constitutions makes the fundamental Bill of Rights as a fundamental issue of justice, including rights like the right to fair hearing, issues like torture, that are absolutely protected by the constitutions. Number two, it matters because, unlike the previous constitutions, it gives an elaborate framework in which all the arms of governments are supposed to be held accountable and to operate in a manner that is in conformity with Kenya's status as a constitutional democracy. We have set out what a constitutional democracy is and what it pertains, and what justice in a constitutional democracy ought to be. And issue number three is that we appear to this court with a lot of privilege for the simple reason that the Constitution says that the courts, and in particular, I dare say, the High Court, is a guardian of the Constitution. So to the extent, therefore, that it is the petitioner's case that the proceedings before you were carried out in such a manner that constitute violations of constitutional democracy in Kenya, and under rules applied in a manner that makes a mockery of why in the first place we have a new constitutions, then we shall be expecting that this honorable court will ensure that the constitutions of Kenya is not in any manner whatsoever violated, because there were very good reasons why we have that constitution in the first place. A while back, I believe this is 1996, I remember because I was a pupil at Kamau Kuria and Keraito Advocates, Firoz Noroji argued an article, very good, giving 10 reasons why we needed a new constitution. I will mention three for purposes of these proceedings. He said, one, because we had ended up having an imperial presidency in Kenya and an authoritarian leader, contrary to the wishes that were understood that would prevail. Number two, he said that Parliament had ceased to represent the people of Kenya and had become sycophantic, and the people of Kenya in political matters and in public affairs had no political representation whatsoever by Parliament. But more importantly, my lords, he said that there was a failure of the courts, and this was the failure of the courts to ensure that justice was administered in accordance with the rules of civilized democracies. This failure of the courts is an important one. And where did the courts fail? I think when I'm talking about the High Court, it is important that this point is made very clear. Mothomi Thiankuru had talked about the common law tradition. We got it from England. What happens and what we got from England is a notion of having a High Court under the adversary justice system, fair system of justice, administering impartial justice based on law and evidence, and the applications of them to specific circumstances. In England, my lords, I believe most of you are aware of that, the full title of the High Court is the High Court of Justice. It is regrettable ours is just called the High Court. Probably it should also go by the full name, the High Court of Justice of Kenya. Why does that matter? It matters from our history, my lords, for the simple reason that when we said, and when, for example, Firoz Noroji wrote about the need for new constitutions because the courts had failed Kenyans, who failed? My Lord, justice in any country and justice in the context of our constitutions can only fail if it fails in the High Court. If justice does not fail in the High Court, you are more likely to have a viable constitutional democracy. It doesn't really matter what happens before the appellate courts. The Court of Appeal, the Supreme Court. Those are appellate courts. They decide justice on the basis of what the High Court has decided. That distinction is absolutely clear, because ultimately, my lords, when the Constitution says that the courts are the guardians of the Constitution, ultimately, and you're aware of 165, Article 21 to 23, and Article 258 of the Constitutions, just the nature of the jurisdictions of the High Court is to ensure that the High Court can be able to discharge its constitutional role as the guardian of the constitutions. Everybody else, all the other courts on top, decides based on what the court has, the High Court has interpreted its mandate to be. And it is on that opening basis that I would want to impress and persuade your lordships that for this very important matter, justice cannot afford to fail before the High Court. My lords, I believe the law reports would confirm that I have been involved in numerous matters of constitutional importance. This is one of the fifth in my book that I believe is the 5 most important cases in this country heard by the High Court. It is important I mention them. In the year 2013, we had the High Court decision in the ICC eligibility case against President Uhuru Kenyatta and President Ruto. That was in 2013. It decided matters that are absolutely important, as we shall be coming to refer to you, and set the stage of ensuring how high voltage political matters ought to be adjudicated upon. Number 2, my lord, we had the famous Maina Kiai case. Everybody in Kenya, including lay people, know about Maina Kiai. Sovereignty of the people is exercised as the polling stations. And we had subsequently the BBI case. We all know the significance of the BBI. The basic structure is an important part of our constitutions. Then, my lord, we had the High Court decisions that would go up to the Supreme Court concerning the budget for the 2023-2024 financial years. Those decisions, for better or for worse, are critically important for purposes of jurisprudence of the Kenyan High Court as a guardian of the constitutions. This is the 5th most important case in my book as far as jurisprudence is concerned in the High Court. And my lord, as it were, just like I stand here today, probably I should have started by saying, you stand on the basis that there could have been another 500 or so constitutional lawyers who could have had the privilege to try to argue these important matters for you. So we are speaking to some extent for the legal profession. The same goes to your lordships. You are a representative of the judiciary. How does this matter pan out in the Kenyan judiciary? In this very important high voltage political matter. My lord, having said that, it is our submission that in dealing with this particular issue and in dealing with the special jurisdictions of the High Court, I believe we have dealt with that matter in several places where we shall be coming to. And mentioning this matter about the significance of this, I believe this was last year, sometime in September 2025. I read in the platform, I believe, on Nairobi Law Monthly, one of them, I have attached that speech by the Honorable the Chief Justice. She said, we have no time to quote, but there is a quotation in our submissions. She said that in marking the 15th anniversary of the 2010 constitutions, it is important that it must remain a living document, that it is important that it must retain its connections to the people, and it must serve the purposes for which it was intended to serve. Those purposes that it was intended to serve are well known, and we have said something about them. What is of crucial importance, therefore, is to say this, that, and this is, I have Githongori versus Attorney General in mind, that in adjudication of justice in this matter, justice must be dispensed in a manner that would make sense to ordinary people. Because it is only by making sense to ordinary people that the Constitution will retain its relevance, its importance, and serve its purpose and value to the people. In paragraph 12 of our submissions, that appears at page 8 to page 19, we have given a summary of what the petition originally filed as 570 is concerned about. And those 5 issues, number one that we have highlighted to summarize what will be coming before you, is that the impeachment proceedings, in the view of my clients, was triggered by a political fallout between him and the 6th respondent. The 6th respondent is His Excellency, President William Samoei Ruto, as opposed to genuine existence of any grounds set out in Article 151B of the Constitution. And the petitioner's case will be that the impeachment against him was part of a conspiracy to use it as a tool for political management and resolutions of political disputes. Issue number 2 is that we shall be arguing that the proceedings before the National Assembly and the Senate were conducted in violations of the substantive and procedural provisions set out and envisaged in the Constitution and the standing orders in the respective houses of Parliament. Number 3 is that the 6th respondent's nomination of the second interested party as Deputy President and subsequent approval by the National Assembly is null and void and should be set aside. 4, that the impeachment of the first petitioner violates the political rights of the 10th to 41st petitioners, and it constitutes an affront on the presidential succession rules, and constitutes a premeditated subversion of constitutional democracy in Kenya, and it constitutes an attendant scheme to re-establish the imperial presidency. My Lord, on this important subject, we have referred, in our paragraph 13 of our submissions, we have cited a speech made by then Prime Minister Raila Odinga upon the promulgation of the 2010, sometime in August 2010. And what he said, it appears there for itself, that what this constitution meant is that it empowered the people. This constitution for him was important, that it dismantled the imperial presidency that we had. And this constitution, more importantly, made everybody accountable in terms of checks and balances that should exist. Those are important issues in our submissions that ought to be remembered as we deal with this important constitutional matter. President Mwai Kibaki himself, at page 17, is where the quotation occurs. He said that it is indeed that we had had a very good constitution that protected the rights of the people. But he warned and cautioned Kenyans that they would need to have a lot of vigilance to ensure that the country will not go back to where it was coming from. And having that in mind, it is why sometimes when I have some discussion with my young lawyer friends like Gachagua and others, I keep on reminding them, you must continue fighting for the Constitution, and the Constitution, somebody must fight for it, otherwise you would lose it. And why is that important? It is important, my Lord, because if the 2010 Constitution is supposed to be an antidote to tyranny, to dictatorship, then eternal vigilance that former President, the then President Mwai Kibaki cancelled is important. And I like reminding him and other young lawyers that, like Julius Caesar is reported to have said, it is I said, Julius Caesar was asked, and how did you turn into a tyrant? Julius Caesar is said to have answered, because nobody stopped me. I believe it is part of our obligations to ensure that tyranny cannot be re-established in Kenya without somebody trying to stop the re-establishment. My Lords, having said that, I come now to the special jurisdictions of the High Court with regard to impeachment. This is set out from paragraph 18 to paragraphs 26. I will highlight two or so things. The important highlight, my Lords, that is important to bear in mind, there is a decision in the Sonko case. This decision has been referred to by many of the advocates. I don't need to go through it. The relevant passage, I have quoted it also. But the critical issue that the High Court, the Supreme Court said, is that it is very important that the rights of the people and the procedure that is adopted during impeachment proceedings are subjected to review by the High Court. It is the High Court that reviews. It is the High Court that protects fundamental rights. Everybody else decides whether the High Court did its job or otherwise. What does this mean? What this means in practical and in a technical sense, and our constitutions, is that Article 48 of the Constitution and Articles 27, the right to protection of law and the right to fair hearing, and Article 50 of the Constitutions. When the Constitution says that you have a right to a fair trial, or you have a right to fair procedures, and you have the right to protection of law, it ultimately means that anybody else who is a court of first instance, whether you are a magistrate, whether you are a tribunal, and whether, like the Senate, you are presiding over a trial as a political court, you are ultimately subject to the High Court. What does this mean? What this means, my Lord, is this, that I consider that an impeachment ultimately leads to the loss of office, the removal of a person from office. These important rights, the rights to protection of law, the right to hearing, those rights, I submit, would mean nothing if anybody can actually leave office, can be removed from the office before the High Court has had the opportunity to rule and decide whether you are removed lawfully or unlawfully. And to the best of my knowledge, the High Court, in all the matters concerning governors, I don't know whether there are exceptions, but all the matters that I am aware, I cannot remember whether there is any governor who was replaced before the High Court had a say on reviewing and determining whether the removal was fair or was in accordance with the law. So that, I am in other words saying, we must have started here on the wrong, or to have had the wrong start. In the sense that, here we had a situation where, despite the very serious issues of violations of law that occurred, the first petitioners nevertheless lost his office and was replaced before the High Court had had an opportunity to say whether this is right or this is wrong. That is fundamental, and that is a game changer, because it effectively means that lower bodies there can be able to administer justice without any supervision and without the right of an aggrieved Kenyan to go to the only court that is truly guaranteed for purposes of ensuring that justice is delivered. So that is an absolutely important issue. And therefore, my Lord, as we also deal with this issue of the special jurisdiction of the High Court, it is also important that I state this, that when you read the constitutions of Kenya, you will find that the Constitution does not provide for the procedure of removing a deputy president. The constitutions provide for a procedure to remove the president from office. The significance of this, you will be able to see it shortly. When you have it in Article 150, Sub-Article 2, that Parliament will be required to modify the procedure for the removal of the president to fit into the removal of the deputy president, that does not change the key issue. The key issue is that when you talk about Article 145, you are really talking, and which is the substantive procedure, that we are really talking about the president, not the deputy president. And more significantly, as it were, and it is one of the grounds we shall be arguing, Parliament did not actually modify, obey the command of the Constitution on what it was supposed to do. So I mentioned that because it will be important. Mr. Mudomi has already said he expects us this matter will not end here. Of course, it is unlikely to end here. And therefore, it is important that there is a second reason why it is not even important that it ends here. Because, your lordships, whatever judgment you will be giving on this very serious issue, you will actually be dealing with the president, the removal of the president by impeachment. The deputy president is just an incidental issue. The Constitution makes it. It's a procedure for the removal of the president. That should be very important. My lords, in paragraph 20 of the Constitution, of our submissions, we have said that in considering the pleadings, the re-amended petition, the submissions that have been made, the following matters are important for purposes of this court exercising that special jurisdiction. That is the legality and propriety of the articles and grounds of impeachment. Number two, the legality, propriety, and compliance with the substantive laws and procedures by the National Assembly and the Senate, and the power to review the proceedings, resolutions, and decisions of the National Assembly, which are vested in this court by the Constitution itself. My Lord, having said that, we go to the issues. I will be going later to what we have said in paragraphs 21 to 26, towards the end. As of now, the issues for determinations are set out in paragraph 27. This is page 13 to page 14. And those issues, we shall try to argue them one by one, except that I need to point out that for purposes of ground C, 27C, whether the first petitioner was lawfully found guilty of ground one of the articles of impeachment, that is one of the issues that my learned colleague, Mr. Martin Kamwaro, will be speaking more on it. I'll just do it in passing. We have said many things about that ground. So that, my lords, to go now straight to the issues that we have raised, is that the first issue is whether the impeachment of the first petitioner was a political witch hunt or a genuine constitutional procedure. This is where we come to the book. In the relevant passages I've cited, it is a case of the petitioners that I am representing, that in the prelude, long before, 2-3 months before Mr. Honorable Mutuse was given a petition to present it to the National Assembly, it was well known that it was being prepared. At that time, it was not known very well who will present it. Originally, it was supposed to be Waluke, all those things, Honorable Waluke, all those things are in the book. Then subsequently, it will turn out to be Mutuse. So that the position of the petitioners that we are representing is that during a political fallout emanating from the time of June 24-25, during that budget crisis and afterwards, it was a well-known fact that the first petitioner and the sixth respondent had fallen out. Those were the political circumstances under which an impeachment motion would subsequently be filed. This is important because I believe it is Lord Denning who said justice must take into account the circumstances in which the crime or in which the violations were occurred. That history is well known, and I believe Law Monthly, they did their book sometime in December of the same year. I believe they had a good recollection on all those circumstances that occurred. Some of us were introduced to be lawyers because of the Law Monthly. So it's a respected publication. But more importantly, my lords, is that it doesn't matter. A long time ago, Alexander Hamilton, in Federalist number 65, wrote that it is not we are not saying it's a surprise that it was political. It would be surprised if it was not. So there is no surprise. Alexander Hamilton, more than 250 years ago, wrote in the Federalist 65 that impeachment is a political process, and it is a political process in which a public officer, a high public officer, not the chief, not everybody, is taken to a court, a political court, in this case designated as Congress and the Senate in the US, for purposes of answering to certain political wrongs that either results into harm to society or threaten the state. And he made it very clear that this court is for the kind of serious offenses. Not the kind of offenses that you have stolen CDF money, it is stolen every day. Those are not things that can be taken for impeachment, but serious crimes that threaten society, that threaten the state. But equally, the more important thing that he said is this: all impeachment proceedings are bound to divide society, because ultimately, the conviction that you have by the court trying the impeachment, in the US, the Senate, it is a court in which votes decide guilt or innocence. So those were absolutely very important issues. And it is the reason why in the US, for example, they had a caveat in their constitution saying that if you are found guilty for impeachment, you only lose office, there is no other consequences that you can stand. They recognized that it is a political process and its very nature. It is not something that is decided by law and evidence. What did we do on our part? But in the US, my lord, it is also important I point out that because, for example, in the US, they do not have the habit of impeaching deputy presidents because they are harmless people in the normal course of things. We shall be demonstrating that. My lord, in the US, where those now impeachments was to take place, to ensure that this procedure would not turn into a mob justice, it would not turn like the trial of Jesus Christ, they said and wrote in their constitutions, it will be presided over by the Chief Justice. And I believe a number of us were around when in 1999, in January 1999, the US Chief Justice Rehnquist presided over the impeachment of President Clinton. And we shall be referring to the impeachment procedure in the US because we have a presidential system. That's why we got this impeachment from. So it is important, the cautions, for example, that were made by Hamilton. So that, my Lord, to say that is then to say this and to point out the irony. How do you tell, and we are coming to these issues of the motion of Mutuse, how do you tell whether these wrongs, nobody is a saint in Kenya, no, how do you say whether this is for impeachment, this for ordinary wrong, for civil courts? There is a very easy criteria. Hamilton said, harm to society, harm to the state. And that is the most appropriate procedure to follow. That if we don't go through the impeachment, then harm would occur to the society or to the state. You understand it very easily when it comes to the president, either in America or here. They are not ordinarily accountable because of the immunity provisions to whatever wrongs that they do. If the president steals $1 billion, you cannot take him to Milimani, any of the courts in Milimani. You wait until he leaves office. But the critical issue that is also important is to understand that it was distinguished. Theft, even under the penal code, is an ordinary crime that you can be taken to the chief magistrate's court and you take a plea. What stage, for example, would theft translate itself to impeachment? Mere theft would not be impeachment. You take people to court 1, chief magistrate's court. At the point at which it becomes impeachment is where the magnitude of theft, the kind of harm that it occurs, result in demonstrable harm to society or to the people. For example, if one were to steal all the budget for free primary education, that is not theft, that is impeachment. Because it would mean that thousands and millions of Kenyan students would not go to school. So that magnitude, nature of the harm is an important issue in deciding impeachment. Alexander Hamilton would fall into this issue. He was involved in some affair, so the story goes. When he was involved in these affairs with somebody, there was some money he paid to that person from the public purse, and he was confronted with impeachment. He said he went to the Congress, to a committee of House of Representatives. He confessed, I had done this, I paid the husband to this woman in order for these people, for this thing to go away. When the committee listened, the committee decided that no impeachment proceedings would proceed because these appeared to be private wrongs with individual failure to obtain matters at personal benefit. They could not be able to say that Hamilton was threatening the US society or the US state, and he escaped from that impeachment. So that, my Lord, that distinction is key, because you've had very many submissions, a lot of submissions. Going to the issue, why would you take the deputy president for things that we have existing law that says that how those matters can be handled, and where the deputy president could actually have been prosecuted the following day, because he enjoys no immunity. There's nothing whatsoever that could have prevented it. So that the point, talking about the motion of Honorable Mutuse, what we are saying is that that motion did not meet the initial threshold that impeachment was supposed to serve in a constitutional democracy. This is to ensure that you protect society and you protect the state. It was never meant to make it easy to settle any political scores or any specific fight fallout that had happened. That would be an abuse of the impeachment process. And therefore it is for these reasons that in our submissions, my lords, we say that out of the 11 articles of impeachment, I believe there are 11, it is only the first one that we believe would meet the test that over and over have been repeated in the US. And this is the fact that the one concerning shareholding, the one concerning discrimination in tribal appointments and all these kind of things. We say that one could meet the threshold of what a person may be impeached. But my lord, we hasten to add, and we shall demonstrate shortly, that it is not, given the provisions of the Kenyan Constitution, that and the evidence that we have put in our affidavits, that was not a crime that could have been committed by the Deputy President. But we are also saying, on the same facts, in an appropriate, good conscious member of parliament could easily have preferred them against the president, even going by the provisions of the constitutions that were cited. We shall come to that issue shortly. So that, my lord, the issue for purposes of ground number one of impeachment is that impeachment did not meet the basic threshold of harm to the state and harm to society. All those other were mere crimes, and we shall be a mockery of a country if we were to say that every other little violations of the criminal law or the laws of ethics or the law of any misconduct is a matter for impeachment. My lord, on this point, it is important to mention that it is no little wonder that this matter is highly contested or it is divisive. In the matter, before I go to point 2, in the only impeachment that we had the advantage to watch bits of it, and we have read a lot about, of Bill Clinton in the US, my lord, it arose from the Monica Lewinsky affair. It proceeded, it failed at the Senate during the trial. But what is important, my lords, and this is important, we bear this in mind as we decide this issue, that the overwhelming majority of Americans repeatedly were not of the opinion that as much as there was moral deficiency on the part of President Clinton, his affair with Monica Lewinsky was a private issue, matters of private morality, not an impeachable offense. This, as we said, as the Chief Justice of the case of Githunguri said, justice must be understandable to ordinary people. The wrongs that we seek to vindicate must be directly connected to them. That a specific serious harm has occurred, Parliament is setting out to punish somebody for that kind of violations of the law. Issue number 2. Issue number 2, we cover it at page 19 of the submissions, all the way to 21. It concerns the issue of whether the first petitioner was impeached by the National Assembly and the Senate under a procedure that violated Articles 27, 50, and 152 or 52 of the Constitutions. My lords, here we can do no better than to deal with a quick summary that we did it in article in paragraph 43. There are various issues, 6 issues why these requirements were not met. First, my lord, we point out is that the mover of the motion must act as an autonomous agent of the law rather than an attack dog of anyone in politics by invoking Article 151. We submit that the 9th petitioner, I believe Mutusa is the 9th petitioner, was not a free agent in the manner in which this motion was taken. Number 2 is that before the MP moves the motion of impeachment, he was enjoined to satisfy himself that there were grounds to believe that it fell within the article set out in 141. We have just demonstrated that no attempt was made to ensure that criteria was met. Number C is that the Speaker of the National Assembly was enjoined to satisfy himself that the motion complied with Article 145 before he could subject it to a vote of the National Assembly. The Speaker of the National Assembly, we have submitted, lacked the fairness, independence, and political neutrality to objectively determine this issue. I believe a case where I was largely involved and where the High Court made an order saying that the neutrality of the incumbent Speaker was questionable has already been cited. So we have authority on the basis of a decision of this court of a 3-judge bench that the neutrality of the Speaker of the National Assembly was an issue. But more importantly, the Speaker of the National Assembly, a motion is received, he says it satisfies the criteria. First thing is a reasoned statement or position ought to have been issued for the simple reason that as Speaker of the National Assembly, not everything must be processed. Before you say this should be voted upon, the issue of compliance with the constitutions is the business of the Speaker. That was not done. Issue number C is that for purposes of Article 144 and 145, he was supposed to ensure that the appropriate standing orders had been modified. That did not happen. And in view of Articles 73, 75, members of Parliament were enjoined to objectively consider and vote on the motion in an objective, intelligent, and fair and conscionable manner. Mob justice treatment is unacceptable under the 2010 constitutions. I believe I've heard previous speakers saying that there was a degeneration of decency, just like Honorable Karanja had said, on how to conduct these proceedings, and for people actually to be able to show, like in the Senate, that we are really jurors. We are supposed to hear the argument and decide. We cannot act as accusers against the Speaker. That protection of the law did not happen. And we are saying the Senate was enjoined to appoint a special committee. I will come to that matter. And that the Senate did not discharge its functions in an independent and fair applications of the law. We shall also be coming to that matter. The point at this particular stage that we need to point out, and it is important we connect this with the Constitution. In the US, the Constitution is a little bit, just says House of Representatives will impeach. They don't give procedures, how these things are going to be done. Then they say the Senate is going to be to do the trials, and the Chief Justice will preside in case of the President. My Lord, there is no requirement under our law that the National Assembly, that before this matter is put to the vote, that there should be investigation, that there should be vetting to be able to ensure that the matter that is coming up for impeachment has adequately, is the one that is actually meant for impeachment. That one is not fair. And the significance of that, my Lord, is this, that for purposes of impeachment, we have a procedure in which anything can actually go, anything that can go wrong can take place, and in this instance, all that could possibly go wrong actually went wrong. And this is why we shall be submitting to tie that with the Senate. That because there is no investigation that precedes impeachment, the Constitution procedure that provides for investigation is an absolute necessity in order to comply with the law and with the rights of a person being targeted for impeachment. In the US, my lord, even in the absence of express rules saying that you should conduct investigation, the House of Representatives, in all instances, they do not go to a vote unless and until investigations have been carried out and what in Kenya we call substantiation has taken place. In Kenya, no substantiation takes place at the positions of impeachment. That it is important, therefore, when we shall be coming to the safeguard that is provided when it goes to the Senate. That safeguard, as we say, also failed, therefore giving to the conclusions that Articles 27, 152, and 50 of the Constitutions were violated. I'll be returning to those issues shortly. Issue number 3 is the important that we shall be doing with my learned colleague, Martin Kamwaro. And that is the issue of ground 1. Ground 1, where regarding Gachagua, the Honorable Deputy President was accused of insightful utterances and all those kind of things, and ethnic balkanization, and trying to go for a policy that would discriminate against members of certain communities. My lord, what we have done, that is a very long part that occupies our submissions. And it goes all the way from page 21 to page 26. We have given a historical account that we shall shortly be able to demonstrate. We have reminded, my lords, that when you go to our constitutions, you find the right to culture. I believe Article 11 is recognized. The preamble to the Constitution recognizes that Kenyans are members of different ethnic communities, but the diversity is respected. The system of devolutions that we have is also supposed to ensure our ethnic, communal, and regional diversity is given constitutional protections in terms of governance, so that ethnicity alone is not a crime. It is recognized that we come from different communities. They have been increasing recently. They used to be 42 for a long time. I don't know whether they are now 45 or the number that they are. But my lord, be that as it may, we have demonstrated in that outline that we have set out in those proceedings that from the word go, and here I have had the benefit to quote my learned teacher, Professor Yethu Muigai, senior counsel, in an important article that he wrote for a book on ethnicity and democracy in Kenya. He pointed out a number of things that from way at independence, Kenya became independent as a country of many communities. To get the independence constitution in the first place, you had to have some ethnic compromise on issues of power and resources. He explains that during the years, the vice of tribalism would creep in on account of the actions of the president of the day, a culture that continues afterwards. So the point that when you read that article, that you understand Professor Muigai to be saying is that these issues of ethnicity, this issue of saying that there has been unfairness in resource allocation has been our reality since 1963. That's the conclusions you come to. We have also quoted a book, a chapter written by Professor Karuti Kanyinga. Professor Karuti Kanyinga comes even with tables and charts with figures showing the manner of appointments to state office and resource allocations from 1963 to 2011. Now, again, Professor Kanyinga, also Karuti Kanyinga, makes the critical point that ethnicity has been the reality of our politics. And power, because, and he explains very well, that because of the nature in which we elect the president, you have situations of coalitions of major ethnic groups. Those major ethnic groups, when now it comes to resource allocations, they always would play a major factor. Because everybody at the end of the day, after you have become president, you want to keep power. And to keep power, you need to do some horse trading. That has always been done with jobs and elsewhere. So what's the significance of all this? The significance of all this, and we have quoted the book of Professor Mamdani. He wrote it recently. The book known as Slow Poison. Idi Amin, Yoweri Museveni, and the making of the Ugandan state. In Slow Poison, Professor Mamdani in the preface explains that whereas belonging to an ethnic group simply connotes somebody in terms of language or in terms of culture, it defines your identity. It is only at that time when ethnicity is weaponized that it becomes tribalism. So that ethnicity and agitation for your ethnic group alone cannot be a crime. The crime happens when it is actually converted into tribalism. That now leads into particularly people being excluded and disadvantage being occasioned against certain groups. To do those disadvantages and elsewhere, you need to be Yoweri Museveni, you need to be Jomo Kenyatta, you need to be Moi, you need to be Uhuru Kenyatta or William Ruto. There is nowhere where all these kind of transformation in which this disadvantage have occurred have been perpetrated by a deputy or vice president, as we ordinarily call them, except in a few situations like Rwanda, where Kagame for 10 years was a real power in Rwanda. In all the other instances, my lords, these are the scenes that we say, presidential scenes in Africa. Even Professor Nwabweze has written about them. So then, my lord, what's the point that we are making? The point that we are making is that in ground number one, and there are figures, we have cited them in our affidavits, to demonstrate that it is actually, Kamaro will be speaking something about that when you actually go to the ethnic figures, even given by the Public Service Commissions, National Cohesion, the figures demonstrate that you have had ethnic disparity over the years and not just right now. So what's the point? The point, therefore, is this, that because those things occur and they are already documented in official public documents of even constitutional bodies, the question then must be asked, who is responsible for those statistics? Because if for purposes of a court of law, evidence is everything. If you can be able to connect that in a certain reality, let's take it 2022 up to 2024, you had this kind of discriminatory appointments and you have evidence to directly attribute them, for example, to the deputy president, it is all that you will need to prove that he is responsible and it becomes impeachable. But, my lords, to do that again, as we have said, you need power. And you need the Constitution saying you are appointing people, yet this is the result you came with. If it comes to budgeting, the question would still be the same. It would be able to be said, and here, ironically, it is Parliament that allocates resources under the Constitution, but that does not stop our MPs from going to State House to seek resources. It is that contradiction of 2010 Constitution. But, my lords, the issue for purposes of allocation of resources, you will need to go to the budget and say, person A is responsible for this discrimination that happened. If you can prove that, I would be the first one to agree that is impeachable. On the basis of the evidence before the motion, it is our submissions. And I followed the cross-examination of Mutuse and his witnesses on this particular issue at the National Assembly. This did not connect. So that it is our submissions, my lords, that for purposes of ground number C, a very serious constitutional issue ended up being trivialized to an extent that as we speak today, the problem, and there were recent figures that were given by the Public Service Commission, the problem remains, but the country is supposed to be satisfied with an illusion that the person who caused this, we removed him from power. My Lord, it is our submission that one of the reasons why the High Court is the guardian of the Constitution is to ensure that this kind of hypocrisy, political hypocrisy, is not permitted. I go to
Council,
the number 4.
You want to reorganize yourself? You have 25 minutes. 25?
I'm actually trying to skip very many things. I will see what I am able to do.
25.
Let's see how it goes. I hope, but we shall get there soon. Let me see the time. So, my lady, we go to the 4th issue. Whether the standing orders under which the first petitioner was impeached violated Article 152 of the Constitution. I think I heard the submissions being made on behalf of the first petitioners, and I've read the submissions by learned colleague Ndegu Wanjiro, and I think I'm satisfied. Time can better be used by adopting what they have said and by trying to adopt a bit of what I have seen. I'm sure Ndegu Wanjiro is going to say. I will only say a simple point on this particular issue. And I will say it together with ground number E. Grounds number E deals with the issue of whether the Senate's failure to establish a special committee under Article 145(6) rendered the removal of the first petitioner as null and void. So what's the summary here? The summary here, Your Honors, is that under Article 145(6) of the Constitution, the Senate was required to appoint a special committee. Why is a special committee necessary? A special committee is necessary, in our understanding, because of the mandate that is given to the special committee by the Constitution. And I repeat, the Constitution, not the standing orders. The mandate of that special committee is to investigate the matter. In this case, the matter of the impeachment of Honorable Rigathi Gachagua. We have demonstrated in our submissions that the Senate actually did understand what was its obligation. There was a motion. The terms of the motion are set out in paragraph 78 of the submissions. That there was a motion for the establishment of a special committee to investigate the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, the Deputy President of the Republic of Kenya. Why, one may ask, was this not carried out? There is a standing order, or rather, I read it from the Hansard, because it lapsed, the motion lapsed. It could not get somebody to second it. A constitutional, Sifuna, who was to second it, said, can read the mood of the House. I decline to second it. constitutional rights cannot be lost because a certain group of MPs thinks that it is within their discretion to decide how compliance is going to be effected. That our constitutional procedure depends on whether or not somebody would turn up to say that I'm seconding it. That will amount to making a mockery of constitutional democracy if it means anything in our country. There was no basis upon which that motion could lapse. There was no basis upon which it ultimately depended on seconding. It was a constitutional command that you have a special committee to investigate the matter. And why investigate the matter? For the simple reason, again, that in our country, even a chicken thief is entitled to the rights to protection of law, is entitled to due procedure. What do those due procedures require? Those due procedures requires, amongst other things, that when your neighbor goes and complains that you have stolen his chicken, he reports, and the OB is, you report it in the OB, somebody at the police station is tasked to investigate, you are called, come and do this and this and this, and then a police officer, ordinarily we call them investigating officer, would come and actually trying to find out the truth. Is it true that there was a chicken that was stolen? Is it true that this is a person who stole the chicken? Even a chicken thief has that right in Kenya. And that is what due process means. The point being, and as I said, that in Kenya, you process things in the National Assembly with zero investigation. It is why we are submitting the Constitution says you must investigate. And it says who investigates and how many members of the Senate. So that in our understanding of justice and due process, unless one can get away of saying Articles 27 and Article 50 and the due process, as we understand it, in very many decisions of this court, the High Court, the Court of Appeal, and the Supreme Court, what they say on due process and procedure. There was a vote in the Senate that was not preceded by the investigation demanded by the Constitution itself. In normal criminal courts every day, in my early years I used to do very many cases. Very good cases would be lost on account of the fact that there was no investigation. And I believe this matter, it is so important that recently, when there was some interviews to pick the successor of the good Justice Muhammad Ibrahim, I believe, one of the candidates, Court of Appeal Judge Francis Tuyot, is captured by the Star newspaper. This appears at paragraph 86 of our submissions, where he was being asked about these matters to do with investigation and why and how it leads to many cases being challenged. Let me quote the judge. I don't want to summarize in the wrong way. He said as follows: the court cannot fill the gaps left by the investigator. If the investigation is defective, the case must fall, because the burden of proof is always on the prosecution. We often see cases where the chain of custody is broken or where forensic evidence is not properly collected. These are not just mistakes. They are a pattern that suggests we need deeper institutional reform in our investigative agencies. It is better for a guilty person to go free than for a court to convict based on defective and hollow investigation. Our duty is to the law and the constitutions, not to public clamor. The pressure of time must not be used as an excuse for a shallow judgment. The public must see that even in those 14 days, the court applied its mind to the critical grievance brought by the petitioners. So that, my lord, the learned appellate judge was saying of something, a basic requirement of our constitutions, that investigations of crimes is important because it is through investigation that you are able to tell the truth from lies. It is through investigation that an opportunity is accorded to the accused to point out that, consider this evidence, it does not show that I was guilty. So that your lordships confronted with a situation where a constitution has said and has provided for a mechanism to ensure there is investigation. The Senate acts as if this is a matter of political discretion. You should be scandalized. The conscience of the court should object to this. And that objections must result that this thing has to die. Justice was not done. Justice was not done in the manner of impartial justice required in a constitutional democracy. I need to explain this further. My lord, there was this important case of Kinoti and others versus Chief Magistrate's Court, a decision of Judge Mrima. Kinoti, I must say, is my partner in my law firm. And this case is important for a couple of reasons. It's a long judgment when you read it. But I quote these decisions from paragraph 87 to 88 in order for three main reasons. The first issue is that it cites several decisions that underscores the necessity of investigation as part of the procedure of administration of justice, particularly in all kinds of justice. Because even before a normal tribunal, there must be fair administration of justice. Because unless you want to have a case of Jesus Christ of Nazareth, if one were to be confronted by a situation where a court system doesn't care whether the allegations are true or not, then that would not be a court in any manner that one would understand it in a democracy, leave alone a constitutional democracy. So that it is those investigations that you care about the truth. Caring about the truth is what can be able to validate our commitment to do justice. So that, my lord, what we are saying is this. Truth became discretional before the Senate. Truth cannot be discretional before the High Court, because its full name is the High Court of Justice. We go to an important decision that was decided very many years ago. I believe it was in the year 2003, and that is the celebrated case of Juma and others versus Attorney General. This is a case, even when you go to committee, remandees knows it. They know the right to be availed statements and the evidence of the prosecution. This decision is important for that reason. It is later on find its better expression in Article 50 of the Constitution. But to the credit of the High Court, that very important decision was made when we did not have a good constitution like we have today. And these decisions, my lord, was saying an important, crucial issue. It says that about the elementary system of justice is one that is justice that is based on investigation, a caring for the truth. What actually happened? Is this man guilty, as the people demanding his blood are saying? That must be the concern of the High Court. It ought to have been the concern of the Senate. Tragically, it was not. Remedy must now come to ensure that is done. And the importance of that decision of Juma, why I'm quoting it today, is that it refers, I believe it was by Judge Kuloba and Justice Mpogoli Msaga. It talked about the value of the adversary justice system and what it connotes. You do not read anywhere in our constitution any description what the adversary system of justice is, but you see features of it embodied in our constitutions. My Lord, the adversary justice system is a procedure in which truth must be founded on those who say this man is guilty have an opportunity to say their piece. Those people who are saying this man is not guilty must have also the opportunity to say that he's not guilty. And at the end of the day, the judge, listening to the partisan speeches, to the partisan position of presentation of evidence, makes a decision on the basis of interrogation of facts and evidence, on the basis of a determinations to inquire into the truth, so that it is a commitment to seek justice through a certain methodology. It is our submissions, my Lord, that justice before the Senate necessarily had to fail, not only because there was no modification, but when senators decided this is a matter of discretion. You cannot. Many cases, like we've read from the learned judges of the Court of Appeal, many cases fail because investigations were defective. The case before you is a case of no investigation. My Lord, I repeat that. Because if you are to have, under the 2010 Constitution, a situation whereby there is a judgment of the High Court saying that justice is done with zero investigation, ordered by the Constitution is okay, one would wonder, why was the fight about? Why did we need to have a new constitution? My Lord, I am absolutely sure that we shall not reach there, and that is why we have tried to be able to demonstrate that that is indeed the case. My Lord, it is also important that we speak about something about the Senate and the structure of impeachment proceedings. My Lord, in the US, that's where impeachment came from. Even here, there was a bit of that I saw. Those people who had the House managers, the people from the National Assembly, who had said they have impeached this man, were given an opportunity to present their case. There was also supposed to be a procedure where Rigathi Gachagua and his team would also be given their piece. The senators, as understood in the US, and as we saw during the impeachment of President Clinton, are jurors. They make the decision. You listen to how the cases have been presented, how the defense has been made. Then in good conscience and in fidelity to the oath of office, you decide, is this man guilty or is not guilty? There was a tragic failure by the speakers, it appears, not to have properly guided the senators. It's for a good reason that lawyers are ordinary speakers in Kenya. It should count for something. It appears not to have counted in this matter. But what's the point that we are saying? In the US, before the Senate, when they say the judge, the Chief Justice, is going to preside over the impeachment of the president, it is because ultimately is the custodian of justice, of fair procedure, to ensure that these politicians, before they vote, they have been guided with the evidence, fair hearing procedures have been availed to the parties, and everybody has ventilated their case. Now, before the Senate,
we had this issue, and some of my landed colleagues have already argued. There is no time limitations. And it is illogical why there ought not to be time limitation. If somebody says, I need an hour or two to properly prepare my case or to defend myself, that ought to be given in the ordinary course of things. Before the Senate and before the National Assembly, we've had politicians, they have had difficulties in giving a fair opportunity for people to ventilate their cases, even when the consequences are very dire. In the US, it took a month. Justice Rehnquist presiding over the impeachment proceedings of Clinton. In the US, no provision is given. How much time do you take? The Kenyan constitutions, when you go to the latter part of the constitution after the report has been submitted, there is no timelines that are given. It's an opportunity that is supposed to be given to now the full plenary and to both sides to be able to present their case. So that, my Lord, if that did not happen, and there was an obsession with the time, you must take 1 hour, you must take 2 hours before an important issue could be resolved before the senators, that was where the tragedy of justice occurred in this matter. And that also, my lords, it must be connected to 2 important issues before I forget them. Under Article 145 of the Constitution, the President and the Deputy President, they have 2 rights of hearing, expressly set out. The right to be heard before the investigating committee, the special committee, and the right to be heard by the Senate, the plenary of the Senate. Those are 2 independent rights to be heard. None is a substitute for the other. Those 2 rights cannot be collapsed because they don't serve the same purpose. My lords, even in all our trials, even in criminal proceedings, and we have discovery in civil proceedings, you have 2 rights. When an accusation is made by the complainant, justice will not be done unless the police also called you to require you to give a statement, to give you a side of the story. That's the first right. This right, in our submissions, is a right that ought to have taken place before an investigator appointed by the Constitution, the special committee. The second right is a second right to be heard by the person who will make the decisions of guilt or innocence. That was supposed to be the senators. The senators did not, at the end of the day, of course, have to have a serious right to be heard. But the more important point that I need to point out at this stage is this, that, my lords, under the Constitution of Kenya, you cannot be an investigator, a complainant, and a judge, and a juror, as it seems to be the case. The case of Kinoti versus Chief Magistrates Court makes that point in better words that we can do. We have quoted that in that case, even a gazette notice that had been done by the DPP was nullified by the High Court on the ground that it purported to collapse those 3 roles to some officers appointed by KRA. So that if in the normal course of things, the High Court protects ordinary people charged with regular offenses, that your due process rights cannot be taken away. It is all the more important, my Lord, that that also be accorded to the first petitioner, unless there is any good reason that, and there is a principle of law that says, no man is too high or too low to be unworthy of the protection of our constitutions. My lords, I urge that fundamental failure of justice is inexcusable and can only lead to one decision. There was no proper vote for the impeachment of the first petitioner. That, of course, goes with the issue of saying, and now that is the next issue, on whether the first respondent, the first petitioner is a subject or is a victim of a political conspiracy. My Lord, it is important to point out that, because this is where my clients are very much interested in, that under Article 75 of the Constitution, when a person has been removed from office, 75(3), that person is disqualified from holding any other political office. My Lords, the first petitioner is interested and is holds a political office, is a politician, and politics is a transactions between leader and people, as it were. We are here because I represent members of his constituency. And because of that particular reason, it is why the petitioners I represent would be very careful about the prospect of the leader of that constituency being barred from contestations of the political office on account of an extremely tragic and defective impeachment. Why does this matter, and where is the entry point? My Lord, we have Article 1 of the Constitution. Sovereignty vests in the people. We have Article 38 of the Constitution, the issues of political rights. The Supreme Court has said, adopting a certain memorandum on standards of impeachment, basically saying that impeachment proceedings must be carried out in a manner that ensures those fights that should be resolved by the people through normal democratic elections are actually solved by the people. So that the right to form government is a right to govern together. That is what Ben Wabweze told us in very many books that most of us quote times without number. The right to get power is a right to govern together. We have annexed the Memorandum of Kenya Kwanza. We have annexed UDA. UDA itself was an alliance that all said what after getting power we were supposed to do together. There was a breach of that democratic contract. That is not just a breach between the first petitioner and the sixth respondent. It is also a breach between the constituency that expected certain representations by its consciously appointed or selected leaders would partake in the governance of the country. Your Lordships, this matters because elections matters in a democracy. But my Lord, the High Court, as a guardian of the constitutions, cannot countenance a situation that in 2027, when we shall be doing an elections, if I figure out that Paul Muite is a very popular leader and he should seek power together with me, in a democracy, the mandate you get from the people is that you will govern for 5 years with Paul Muite. But my Lord, if it turns out that Paul Muite gets you to get to the office, and then 2 years or 1 year down the line, you want to remove Paul Muite and replace him with another person, two obvious questions would have arisen. And that question is, why did we have to go to the elections? We go to the elections in order to get the political elite that will be responsible for our statecraft for 5 years. But it turns out, my lords, that there is any single person alone or in conspiracy with others who can be able to change the nature of the democratic mandate obtained through an election. That would be a grave violation of democracy as ordinarily understood, but more importantly, of constitutional democracy in our country, because the constitution of our country, I think the Article 3(2) says it is unlawful to establish government otherwise than in accordance with the constitutions. In Kenya, government is established pursuant to an elections. It is therefore, my Lord, our submissions that a scenario in which the very foundations of our democracy is contested, becomes disputed, that state of affairs cannot be permitted. Recently, in the case of Governor Guyo, a 3-judge decisions of the High Court explained, we have quoted it somewhere, explained at length that the nature of our constitutional democracy is that you must respect the people. The people appoints you in this party, gives you a mandate to govern with this manifesto. That must be respected. Because if it doesn't, democracy fails in the most fundamental sense, that it ceases to be a transaction where government, in the words of Abraham Lincoln, is a government of the people, for the people, and that is supposed to serve their purposes. So that, my lords, for purposes that happened, water under the bridge. The first petitioner said, I no longer want the office. That right must be respected. But what is important is this. Still on account of the same impeachment, if there can be no lawful government in my reading, in the reading of the petitioners I represent, between the impeachment of the first petitioner and the next general elections, it is important that the government that comes to office in Kenya in September 2027 will be a government established in accordance with the constitutions of Kenya. How do you get that government? That is the end point. How you get that government is to ensure power is contested by everybody eligible on account of the constitutions of Kenya, without limitations imposed politically in order to secure political advantages. The case of conflict management, the ICC case, what was it all about? William Ruto and Uhuru Kenyatta are having ICC charges. They are not eligible to vote. The High Court decided many things. Some of the 3 that are important, that I wish to highlight, that he decided are: number 1, that the issue of who governs Kenya with a written constitution is a decision that belongs to the people. The people are the best suited to decide on that issue. Issue number 2 that you get from that decision is that, given the history of our Kenyan nation, we had situations, you had it in 1969, you invoke a rule of procedure to get all candidates of Jaramogi's party debarred from contesting office. You had a situations whereby you could say that the day of nominations are 2 hours. Then you abduct your opponent. Your opponent does not submit their papers. Those are the kind of things that, in retrospect, the High Court in that case was saying are not permitted under the constitutions. That Article 38, the right to seek public office and to be voted, mean exactly that, and must be respected and cannot be derogated without justification. Issue number 3 from that case was this. It was the fact that And that was for TNA. TNA had nominated William Ruto and Uhuru Kenyatta for their ticket for that year. And I represented TNA in that case. The right for TNA and its members to have William Ruto and Uhuru Kenyatta contest the elections was upheld on the ground that politics means nothing if the leader that best expresses your political aspirations in politics can just be disqualified, can just end up not being a candidate. So they upheld that right and said, for that right to be taken away in Kenya, very onerous standards would be required. In the case before you, my lord, that onerous standards would be this. I'm about to finish.
Please.
Yes. That onerous standards would be this, that we have actually confirmed that there was a good impeachment. There was no malice. That we had a good parliament that could do the job. But what are we facing, my lords, before you? The scenario that we are facing is that we used to have the 6th parliament. The parliament that we had between 1988, the 6th, 1988 and 1992. It is a parliament that got rid of Dr. Karanja from his office in the manner that was described properly. Now, we also have the 13th parliament. We have its record of impeachment. I thank the lawyers for Parliament for giving us the full answered reports. You read them. If you are with foreigners, we have read impeachment proceedings in other countries. I wonder how proud one would be to say, these are Parliament. But that's not the important point. The important point is this, and we have the headquarters of Sifuna. Before somebody can be able to say that we do our job, we honor the constitutions. Constitution says Parliament be independent. It says protect the interest of the people. We have on record in our headquarters Senator Sifuna saying that he had observed, he said that in an interview with Cyrus Jirongo. He said that he observed that when the issue of the reductions of money to counties was taken to the Senate, he found it odd that senators voted against their counties getting more money. Yet the Constitution says you are in Parliament to protect the interest of counties. My brother, friend Degwajiro, has shown and tabulated in his submissions what people are saying during the time when they ought this or the other one to be done. We had in June 2024 a scenario whereby there is a national clamor saying this budget is bad. But it had to take an invasion of Parliament for these same members of Parliament to change their mind and to turn around and say, oh, it was a bad bill. What's the point we are saying? The point we are saying is a simple one. Before you say a good impeachment was passed, one must take a verdict of some kind and say, what kind of parliament is this? If a parliament looks like the 6th parliament, and we know all that used to happen during its time, then that cannot be a good parliament that will decide matters of life and death in the good constitutions of Kenya, and that can very easily attack our constitutional order. The final point, so that Mr. Kamaro can say his bit, is this, that there is an important issue, that an important right. I don't know whether there is a smaller section than that, but I like Article 28 of the Constitutions, the right to human dignity. That right to human dignity is actually a very brief provision. It says every person has inherent dignity and the right to have that dignity respected and protected. What does that mean on a day-to-day nature of things? What that provision means as applied in the context of this matter would be to say that in a country that Article 24 says we should be civilized and we should respect fundamental rights, if somebody says, I'm sick, and can I be heard on another day? That unless there is a very serious and express and explicit prohibition by the law, in a civilized society, you would have honorable senators and speaker permitting such a person to be heard on another day. It is something all of us lawyers, we know every day. In fact, it is only a very few lawyers, one judge had to ask, counsel, can you object? Your friend has said he's sick. You want us to proceed when he's sick? It is one basic courtesy because it rises from human dignity. There is a decision a while back that, this is the last point, a decision of Daniel Ogwaka Manduku and versus DPP, a decision by Judge Ogola that spoke something about the right to human dignity. I've read that decision. When I read that decision, it didn't appear like the judge was convinced that the petition had been filed properly. But at the end of the day, I saw the judge giving anticipatory bond. And why did he give anticipatory bond in that circumstances? He premised that on the right to human dignity. He said as follows, I don't want to quote him wrong. The purpose of bond or bail is therefore meant to treat suspected offenders with some measure of dignity. This dignity should be accorded to every citizen or suspect. The petitioner here prays for a bond or bail pending arrest should that happen. Arrest in Kenya, this is an important part. Arrest in Kenya has become a public spectre. And I should think the prospect of being arrested is the most devastating emotional issue for the would-be suspected criminals, more so if they hold high office. In Kenya today, the public waits with bated breath whenever a senior public servant is rumored to be required for arrest. In a primitive society, very important, that would be the day when villagers met at a public square to witness public execution of public offenders. It, however, needs not be so. Every Kenyan should be arrested with dignity and be given a reasonable chance to apply for bail, either before or immediately upon arrest. Whilst at this, I found out that the theories of arrest against the petitioner are speculative, and the petitioner would still be given rights. At the end of the day, the important of the case is that that bond that was being requested was granted to avoid a situation where the right to human dignity would be violated. In this particular manner, at that time I was watching from television the proceedings before the Senate when Paul Muite applied for adjournment on account of sickness. That was not granted. I remember one of my daughters, I believe this was Sheba Waidera, asking, why was that right not given? I was angry. I told him, these senators are biased. That's the only answer I could give. After some reflections, I told her, I think when this matter, I am aware impeachment goes to the High Court. I think when this matter goes to the High Court, we shall tell the High Court that was wrong. Mr. Kamwaro.
Thank you. Thank you very much. How much time did you ask?
30 minutes, but I'll try to finalize in 25 or less.
We'll give you 20 minutes.
Most obliged, my lords. My name is Martin Olekamwaro. I need not to go deep into what my learned senior has done. But let me say this, that on behalf of the petitioners that we represent, their petition raises what the petitioner characterizes as a textbook parliamentary coup, the impeachment of His Excellency Rigathi Gachagua, the first petitioner as the Deputy President of the Republic of Kenya on 17th October 2024. My lady and my lords, I will try to summarize so that the others can also utilize judicial time. We have made a quote in our submission of Frederick Bastard that speaks with striking precision to this case, that when plunder becomes a way of life, a legal system is fashioned to authorize it. My lords and my lady, this is not, in truth, a case about impeachment. It is about the use of constitutional process to legitimize a predetermined political outcome. The charges that face the first respondent, particularly anchored on crimes under National Cohesion and Integration Act, Section 1310A and 62 of that Act, on the issues of ethnicity or issue of the so-called shareholding. But the record reveals a profound inversion, that those who are alleging that he uttered words of ethnicity or tribalism are themselves operating within it and benefiting from the very logic they purport to condemn. Our submissions, my lords and my lady, demonstrate the issue was advanced in a manner steeped in institutional hypocrisy. Parliament was weaponized. The impeachment that shocked our republic. My lords and my lady, we need to handle this matter with clear minds. Ethnicity in this country and tribalism has acquired a dangerous mutation. Those who practice it most aggressively are those often its loudest accusers. Evidence is not in rhetoric. It is in appointments, in access to offices and corridors of power, and the quiet architecture of state power. We see, my lords, patterns in public office become a gateway for ethnic favorism, in which the first petitioner is accused of, where proximity to power translates to disproportionate advantage into public appointments. If you take an example of the community where I come from, as you compare with similar numbers in the Republic of Kenya, you will realize that somebody from a community can actually hang himself or herself considering the appointment that the community is allocated, for example. But that's for another forum. Yet when it comes to political expedient, the same actors, the real tribalists, turn out, accuse others, and claim moral authority. Who then are the real persons practicing ethnicity and tribalism in our country? Is it the one who is wrongly accused, the first petitioner in this case, or those who convert the instrument of state into pipelines for tribal patronage? My lords and my lady, the accusation is easy. Consistency of conduct is a true constitutional test before you. And on that test, it is the first petitioner who stands exposed. It is also his accusers.
My Lord, Article 150 creates a constitutional safeguard and not a political weapon. It demands, one, proof of the accusations leveled against you. Two, the threshold that must be met as per our Constitution. And three, fidelity to the due process, which my learned friends who spoke before me have highlighted. Then what then occurred in the National Assembly and the Senate? Number one, a political fallout recast as constitutional violation. Number two, a process driven by alignment, not evidence. You have heard many of them say, we have the numbers. The Constitution does not envisage that situation. Impeachment, as is prescribed by the Constitution, is not we have the numbers, so mutadu. A charge sustained by narrative, not proof. My Lord, the issue is not whether the tribalism is undesirable. This is what it is. Can unproven allegation advanced by those who are themselves embedded in the worst kind of tribalism to be visited upon Kenyans satisfy the constitutional threshold removal? My Lord, if the answer is yes, then impeachment becomes, one, a tool of convenience, a mechanism of political sanitation, and thirdly, a precedent for removal without proof. If we allow that to proceed, my Lord, we will not have a republic. My lords and my lady, you will find that in the motion and the proceedings that were before Parliament and the Senate, no evidentiary standard was met. Number two, no constitutional threshold test was satisfied. No fair application of Articles 27, 50, or 150 of our Constitution. What remains is not a legal finding. It is a political conclusion dressed in a constitutional language. If this process is allowed to stand, my lords, evidence will become optional. Allegation will become sufficient. And three, impeachment will become modern instrument of political elimination. At that point, my lord and my ladies, the Constitution will not restrain power, it will serve it. My lords and my lady, this case is not about mere removal of a public officer, the first respondent. It is about whether the Constitution can be bent to serve a political moment. We have quoted in our submission S.S. Smith when he said, constitutionalism is practiced in a country where the government is genuinely accountable to an entity or organ distinct from it, where there are effective legal guarantees of fundamental civil liberties enforced by an independent judiciary. And that's why we are here before you today. The reliefs sought by the 10 to 41st petitioners are contained in our petition, amended petition, and I need not to go to it in the interest of time. But let me say, let's look at these submissions and the petitioner's case from a constitutional flashpoint. What this case is really about. I want to stand here and say, this is not about an election dispute. This is not an election petition. It's a fight for the soul of the Constitution, the soul of this document. That's why we are before you today, my lords and my lady. The three reliefs that I can summarize in the consolidated petition as re-amended are these: that the first petitioner was impeached under a procedure that violated Article 27, 50, and 152 of the Constitution. These are equality before the law, which my learned colleague has elaborately stated, fair hearing, and specific procedure for removal of a deputy president. Number two, that the standing orders number 64 and 65 of the National Assembly Standing Orders, 6th edition, as well as standing orders number 78 and 79 of the Senate, as applied, offend, my Lord and my Lady, Article 152 of the Constitution, the very provision that prescribes how an impeachment is supposed to be conducted. My Lords, the impeachment proceedings against the first petitioner was triggered by a political fallout between him and the sixth respondent, the President of the Republic of Kenya, as opposed to a genuine existence of any of the grounds set out under Article 151B of the Constitution. The proceedings, my Lord and my Lady, before the National Assembly and the Senate were conducted in violation of the substantive and procedural provisions set out or envisaged under our Constitution and the standing order of the respective chambers of Parliament. The Honorable Court is obliged to quash the impeachment of the first petitioner in order to remedy the gross violation of the Constitution and prevent further subversion of Kenya's constitutional democracy and the attendant scheme to establish an imperial presidency. We need to look at the legal anatomy, the constitutional violations at a glance. Article 27 on equality of freedom from discrimination. The question is, why does this provision matter? It matters because the question will be, was the Honorable Gachagua singled out by a procedure unavailable to any other citizen? Did Parliament apply double standards in the manner in which it conducted impeachment proceedings against the first petitioner? Article 50 on fair hearing, my lady and my lords, was the impeachment conducted according the first petitioner a fair, adequate, and transparent hearing. The right to be heard is not a technicality, my lord and my lady. It is the backdrop of due process. Much has been said about how the hearing was conducted, even when he was in hospital and was battling for his life. Article 152 on the removal procedure itself. The Constitution prescribes a specific removal procedure. The petitioners say Parliament should change, my clients are saying that the Parliament should change and short-circuited it. If Parliament can alter how a deputy president is removed, my lord and my lady, no constitutional office is safe. Standing orders on National Assembly and the Senate. These are the internal rules used to run the impeachment, are themselves unconstitutional. And my colleague has already stated that. The vehicles of the removal are as tainted as the removal itself. My lord, the petitioner's submissions are anchored not just on law, but also the political reality of our country. And the court cannot ignore this. These scenarios are foregrounded in the opening pages of our submissions. This is what Edwin Sifuna said, and is quoted. William Ruto has basically taken over Parliament after the success that he achieved in putting Parliament in his pocket. He has now fixed his eyes on the judiciary. We are going to lose this entire republic. That is Senator Edwin Sifuna, Senator of Nairobi. No, I'm just quoting what he said. It is in our submissions. My lord, the whole state is in arms. That is what Julius Caesar said, 100 BC to 444 BC. And he said, the whole state is in arms. What is then aim of all these preparations but my destruction? Gibson Kamau Kuria, senior counsel, is also cited in our submission, said, the country which started nationhood in 1963 with a constitution which set out to create a tradition of a limited government has an unlimited government which is unmanageable, unable to manage its affairs today. These are not rhetorics, my lady. They are the framing narrative that the impeachment of Gachagua was not an isolated parliamentary act, but a constitutionally dangerous precedent in a republic where separation of power is increasingly fictional. We have cited in our submissions what Dr. Kamau Kuria gave 4 scenarios. The stake could not be higher. He gave a scenario of France of 1789. I had the opportunity of studying European English, European history from 5 and from 6, and Yugoslavia. And this is what Kamau Kuria said, whose words are abducted in our submissions, identified 4 catastrophic features Kenya now contemplate. The first scenario, Kenya becomes France of 1789, or Russia of 1917, a revolution born of constitutional collapse. Scenario number 2, Kenya follows the Somalia, Liberia, Sudan, or Uganda way, a state of fragmentation and perpetual instability. 3, Kenya travels the path of Ghana and Nigeria, circles of democratic failure in former British colonies. And 4, Kenya fractures like Yugoslavia, ethnic enclaves replacing a unified republic. The petitioners...
Can I take you on your word?
Yes.
In the next 5 minutes, you can try to wind up.
Kindly, my lady, I'm just about to finish. I'm running. Now, my lady, the core oral proposition, the argument for your determination is this: 5 points. The petitioner will submit as follows. 1, the proposition number 1. The first petitioner is not guilty of ground 6 of the articles of impeachment. The first petitioner was primarily impeached on the basis that he committed crimes under sections 13, 10A, and 62 of National Cohesion Integration Act. The issue of shareholding. I know my colleague here is my friend here. Now it's abandoned the issue of shareholding. He's talking about power. That is my senior colleague. Our core position has been amply pointed out by my colleagues before me, is that the said charge, even when taken at its highest, is not an impeachable offense to justify the removal of the first petitioner from office. There is an element of hypocrisy in the way the issues of shareholding and tribalism was handled by both houses of parliament. Our constitution, my lady and my lords, envisages and encourages ethnic, cultural, religious diversity. Even the concept of revolution is founded on recognition of culture and ethnic identity. Therefore, in the face of Kenya's diversity, the Constitution requires that various state officers led by the President should take into account ethnic and regional diversity in making public appointment and allocation of resources. It's not a new concept. It's in the Constitution. The key point here I'm making is this. Then, is that both ethnicity and tribalism, isn't it that both ethnicity and tribalism realities of a national existence and political dealings? And so this subject must be handled with sensitivity and wisdom as opposed to trivializing or sensationalizing it. Further to the foregoing, it is worth noting that it is the 6th respondent, rather than the first respondent, who can legally and politically be held responsible for skewed public appointments and resource allocation that remain to date a major factor of Kenyan politics. This court should take judicial notice of the manner in which the 6th respondent has systematically appointed state officers to public office, primarily from his ethnic tribe. Yet even it's not subject to impeachment proceedings as the first respondent, by way even when the first respondent never made any such appointments. Proposition 2, Parliament cannot rewrite its own rules to unseat a deputy president. I'm about to finish, my lady. Article 152 of the Constitution is not directory. It is mandatory. The procedure for removing a deputy president is constitutionally prescribed. Any standing order that deviates, breaches, or short-circuits the procedure is pro tanto void. Parliament cannot, by a majority vote on its own internal rules, amend this constitution. Article 50 guarantees every person the right to fair hearing. The question is not whether Gachagua was given some hearing, but whether the hearing was fair, adequate, and constitutionally compliant, or what my senior colleague Ogala said, malicious compliance. Ongoya. The petitioners on the proposition number 4, equality before the law, means equality of procedure. My Lord, equality before the law also means equality of procedure. Article 27 is violated where a procedure is deployed selectively in a manner that treats one constitutional office bearer different from the standard the Constitution prescribes. The petitioners will demonstrate, and the one that we represent, that the procedure applied in the case of Gachagua would have been impermissible by any other proceedings. 5, impeachment was a symptom, not the disease. The deeper constitutional malady, as the petitioners will argue, is the capture of parliament as a deliberative institution. When senators vote for less money to go to their own counties on presidential instruction, the constitutional architecture of devolution and legislative independence collapse. It is our submission, therefore, that the 13th Parliament has been captured by the executive to an extent that it is no longer possible to consider it as an independent arm of government, or as the Nairobi senator eloquently observed in the quotation that I've just said. So it is our submission that the sixth respondent was ultimately responsible for the political conspiracy and mobilization that enabled the impeachment of the first petitioner from the flimsiest reasons and procedural scandals. In doing so, the sixth respondent abused presidential power in causing the impeachment of the first president of the first petitioner after their fallout. Finally, on an independent judiciary is now this. This is our last line of defense, this court that we are today. Senator Sifuna won. Okay, I'll skip that.
To be quoting Senator Sifuna every time. When he's not an authority, he does not make any statement. I don't know what obsession.
Relax today, you know,
if Professor Ojenda says something worth quoting, he should be guaranteed I will quote him.
My lady, as I finish, because I'm just a minute to I'm finished. My lady, the 10th and 41st petitioner submit and will argue orally that the issue of declaration sought in the re-amended petition confirming the unconstitutionality of both the impeachment procedure and the standing orders that enable it. Number 2, affirm unequivocally that Article 152 of the Constitution is not amendable by parliamentary resolution, standing orders, or executive instructions. Number 3, send an unmistakable signal that the separation of powers and the independence of the constitutional office are not negotiable. And finally, vindicate the constitutional rights as outlined under Article 27 and Article 50 on equality before the law and fair hearing, in the circumstances where those rights must be visibly and consequentially at stake. So I submit. I've shortened my submission.
Thank you.
My Lord, Ms. Koira will only have less than 10 minutes to say something.
I want to know how many...
on our side is enough.
Yes.
Yes.
Because we want to structure our proceedings such that when we break for lunch, we come to start the respondent's case. So how many submissions do we have from petitioners?
I think now we have argued like 3. There are 4 more to go.
Hmm?
Are they 3? 3 more?
Yes.
Yes. But the rest were short as we are done. He's taking less than 10 minutes.
So how many do you have? You are how many? Please stand up if you intend to submit.
Yeah, my lord, I'm yet to submit.
How much time will you need?
Like we all agreed before this court, 1 hour. We have very substantive submissions to make, my lord, representing a petitioner.
And you? 15?
We have interested parties in support of the petition.
You take how much time? 20 minutes?
I'll take less than 10 minutes.
So divide it by 2 and then proceed.
My lord, good afternoon. The matter. My name is Koira Kimani. My lord, a lot has been spoken by the two speakers who are before me. I wish to not regurgitate that information that has been given, but just to say 2 things, my lord. The impeachment process that the first petitioner was subjected to is one that has raised a theme of fair hearing. In particular, my lords, I will be referring to paragraph 47 of our submissions. There we reference the grounds 1 of the articles of impeachment. In that ground, Your Honor, it was submitted, and I quote, that His Excellency regarding Gachagua's divisive and insightful public utterances over the last 2 years were incompatible with the high calling, stirred ethnic hatred, and falsely alluded to a non-existing government policy to discriminate. My lords, it is the submissions of the petitioners that there had to be a particularized statement following that charge in which the deputy president could respond to. There was none. These statements were very speculative, and in any case, no proof at all was ever produced before the August House to reference that there was indeed a government policy that appeared to suggest certain communities were being segregated or discriminated from the enjoyment of the services that were rendered. Number 2, my lords, we wish to submit that as a deputy president, the first petitioner is the principal, his role is just to deputize the president. It therefore follows, my lord, that if there was any action to which the first petitioner could be subjected to impeachment, then that process had to be within the framework of Article 147, what was delegated to the deputy president in his exercise of the function, and what is it that he did that did not align with the mandate. Any other issue that the deputy president was impeached that didn't follow within the framework of Article 147, then that was a private issue, and there is a cause that any aggrieved party ought to have followed other than the impeachment process. My lord, lastly, allow me to make reference to our prayers in our amended petition, and specifically prayer number 6 and prayer number 7. For good record, we state that a declaration be issued to declare that the 14 days period prescribed under Article 149 for the President to nominate a person to occupy the office of is to ensure compliance with Article 10, 38, 99, and 137, and thereafter, a declaration be issued to declare that the 60 days period prescribed under Article 149 of the Constitution to the National Assembly to vote on the President's nomination. My point is this, my lords, is that there's a time frame in which these things have to be done. It wasn't it's a matter that is cast in stone, that there is a difference between the 14 days of nomination and number 2, the consideration of 60 days. A lot has also been submitted before this bench in relation to public participation. My Lord, when that order of Kirinyaga was made that public participation be done, my Lord, we were not even granted, Kenyans were not even granted 10 days out of the 60 days, my Lord, to put in their concerns about the choice of the deputy president. My Lord, it also follows that under our political democracy, the presidency, it's a matter of a conjoined twins. You come in as a president with your deputy president. For various reasons, my Lord, I wasn't for the president, but I elected him by virtue of the first petitioners. That being the case, if then they were not okay with the vice president, any Kenyan who actually made a similar finding while voting ought to have been granted sufficient time to scrutinize the candidature of the incoming deputy president to ensure to vote. And why am I saying this, my lords? Post-election, post-clearance by the IEBC, candidates, all political candidates are granted almost an average of around 90 days to do a campaign, to go to the people, to convince the people that I'm the right person to lead you in this country. But when it comes to nomination, my Lord, of the deputy president, to which I participated in voting, I'm only granted a day, 2 days, a trial of 1 day. There's a reason as to why, Your Honor, the Constitution puts a 14-day timeline on presidential petitions, whereas there has been debate to extend that timeline, but it's 14 days. That is to ensure that, of course, there's no urgency, because if we were to follow then the reason, if this bench was to say that that impeachment process was lawful, it means this country is yet to see probably a declaration of invalidity or validity of an election, presidential election outcome within 1 day, and to say, but the petitioners and the respondents were all granted time, and a decision was made by the Supreme Court either within 1 day or within 2 days. My Lord, that was not the intention of the citizens of this country, and we urge you to accord us the prayers that we've sought in our amended petition. Thank you, my lords, and I'll be to seat.
Thank you.
My lords, that is all for the 10th to 41st petitioners. We request that the further re-amended petition be allowed.
Thank you very much. Mr. Ndegwa will give you 45 minutes. Don't go beyond 45. Yes.
I will let you know when you have 10 to go.
Again, I will try my best. Thank you, my lords, my lady. Permit me to begin by indicating that as we appear before you this afternoon, the heavy weight of our Constitution, or rather I feel the overwhelming weight of our Constitution resting over my shoulder. It's my sincere hope that this weight, during the time of the interrogation of the submissions, will equally continue to rest on this court's shoulders. Why do I say so, Your Lordship? I say so because it is important for us to begin by understanding the preamble to the Constitution. When we were giving ourselves this Constitution, these are some of the sacred promises we gave unto ourselves. One of it was that we recognized the aspiration of the Kenyans people for a government.
You have 44 to 49 petitioners.
Yes, 44th to 49.
Yes.
I indicated, my Lord, that when we gave ourselves this Constitution, the people of Kenya recognized their aspirations for a government that is based on essential values, human rights, equality, freedom, democracy, social justice, and the rule of law. That is what we promised ourselves. Number two, we promised ourselves to exercising our sovereign power and unalienable rights to determine the form of governance of our country, and we give it to ourselves and the future generation. That is why I said, Your Lordship, that this case before you is not about His Excellency Rigathi Gachagua. It's about the posterity of our nation, the success of our democracy, and the fidelity to our constitution. I therefore wish to submit that I participated in these proceedings during the Senate, and I submit that there was no impeachment that took place at the Senate. All what happened at the Senate, my ladies, my lords, was a mockery of an impeachment, a travesty of justice, the transgression of our constitution. Your Lordship, it has been submitted earlier on by my learned friends that the question that begs the mind of this court is, was this the most appropriate avenue of addressing the alleged transgressions? Or is impeachment contemplated by our constitution as a matter of last resort? I submit, Your Lordship, that impeachment, though a constitutional tool of enhancing accountability and good governance, must be deployed as a matter of the last resort, and especially to a person holding the office of a deputy president. Why so, my lords? Because we must be able to distinguish between the impeachment that is designated for a president and an impeachment that is designated for a deputy president. And the point of departure, Your Lordship, is Article 143, that the deputy president enjoys no immunity from criminal and civil proceedings. That is to say, if there is evidence that the deputy president has committed illegal transgressions, the avenue that is applicable for addressing that particular issue is to interrogate the law applicable in addressing that particular issue. So that, Your Lordship, that you subject these individuals or this individual to a process that will be less injurious to the sovereignty of the people. Remember, the office of the deputy president, Your Lordship, though derivative of the office of the president, is distinguishable. And that's, Your Lordship, Article 150 of the Constitution, as read together with Order number 76 of the Standing Orders of Senate, requires Parliament, that is the Senate, to enhance the necessary modification when initiating this process. Your Lordship, the Constitution provides, under Article 150, Clause 2, that the provisions of Article 144 and Article 145 relating to the removal of the president shall apply, with necessary modifications to the removal of the deputy president. This necessary modification, Your Lordship, is supposed to appreciate the fact that the deputy president enjoys no legal immunity, and hence inviting the person who accuses him or her to deploy other legal mechanisms that are available to address the grievance. Your Lordship, we submit that there was serious transgression of this provision, that the Senate did not deploy the modification of its standing orders and this procedure. The failure to modify, Your Lordship, meant that the deputy president was therefore impeached under Article 144 and Article 145. he was impeached as though he is the president. And that is a transgression and the violation of the Constitution. The evidence on Mr. Nyengenye's affidavit in regard to the Hansons will bear as evidence that the Speaker did not deploy the modification mechanisms. The failure to modify this mechanism, Your Lordship, meant that the Deputy President was denied the available legal tools under Article 50 of a fair hearing. Your Lordship, this modification, Your Lordship, means something. It is meant to address something. It is not just there to decorate our Constitution. It was imperative upon the Speaker to inform the Senate of the necessity to modify the procedures for impeaching the Deputy President. Number two, Your Lordship, permit me to draw your attention to Standing Order number 78. This Standing Order number 78 has been addressed vigorously by my predecessors, but let us look at it from a different perspective. The Senate is saying that the Speaker shall, within 14 days, convene a meeting of the Senate to hear the charges against the President, read Deputy President, comma. And the Senate, comma, by a resolution, comma, may appoint a special committee comprising of 11. My humble submissions, my Lord, is that we have two avenues or two forums where this impeachment can take place. The first impeachment is where the Senate sits as a plenary and as it did. The second avenue is where it contemplates by its resolution to create a special committee. Be that as it may, and even if we were to evaluate the two scenarios, the question is, the scenario and the mechanism that was deployed in the impeachment of the Deputy President, did it end up in upholding the Deputy President's rights? Your Lordship, it's my humble submissions that the Senate could equally impeach the Deputy President through a plenary. But when initiating this plenary mechanism, the Constitution, the Standing Orders requires that there be a modification so that this modification will put into place the rules of procedure to ensure that fair hearing is achieved. And this fair hearing, Your Lordship, you'll find it at Order number 80, the right to be heard of the Senate. Whenever the Constitution or any written law requires the Senate to consider a petition or a proposal for the removal of a person, the person shall be entitled to appear before the relevant committee of the Senate to consider the matter, and the Senate and shall be entitled to a legal representation. Your Lordship, my argument or my submission is that even when the Senate decided to deploy the first forum of the Senate being the impeachment crowd as a plenary, they did not provide the procedures for the impeachment that would have ensured that the right to a fair hearing is accorded to the Deputy President. What that means, Your Lordship, is that the Deputy President was denied an opportunity under Article 27 of equal protection, equal enjoyment, and equal protection before the law. That amounted to a transgression. It amounted to an infringement. It amounted to a violation. But Your Lordship, again, you might want to ask yourself whether the Speaker had the responsibility and the duty to guide the Senate. When the Senate realized that they are going for the plenary and the plenary has not provided for the mechanism. Order 1 says, Your Lordship, of the Senate rules, in all cases where matters are not expressly provided for by the standing orders or by other orders of the Senate, any procedural question shall be decided by the Speaker. The Speaker did not deploy this mechanism. The Speaker did not initiate this provision. That is to say, Your Lordship, that the Senate fell into serious legal error, fundamentally breached the Constitution and its own standing orders, Your Lordship. Your Lordship, therefore, you must want to ask yourself, in a situation such as this one, was there an impeachment? Your Lordship, it's important for us to remember what Wambora 21, Civil Appeal number 21 says. Civil Appeal number 21, which my learned senior counsel Paul Moite indicated that I was involved in its development, contemplates a two-tier approach to the impeachment. The first tier is where the judges of the Court of Appeal says that this is a political, quasi-judicial process. A quasi-judicial process, Your Lordship, is a tribunal. The Senate sat as a tribunal. The Parliament, National Assembly, equally sat as a tribunal. When it is sitting as a tribunal, it cannot be exempted, Your Lordship, from the dictates of a fair hearing, equal protection of the law, and all procedures that invites it to uphold the Constitution. It's my humble submission, Your Lordship, that in the absence of the provisions that I have quoted, Your Lordship, this could not have been said to have amounted to an impeachment. Your Lordship, that decision, Your Lordship, the Wambora decision, the judges of the Court of Appeal relied in the case of Madbury versus Madson. And this is what the judges said. It is at paragraph 32, Your Lordship. It is our considered view that insofar as the process of removal of a governor, read Deputy President, from office is concerned, the province of the court is solely to decide on the rights of an individual and not to inquire how the county assembly or the Senate performed its obligations. So even when there is a violation of a right to lordship, our submission is, if the court finds that Article 50 of the Constitution was violated, and it was a right that was available to the Deputy President, or Article 27 was violated, and that right was available, then the court must pronounce itself by making sure that it admits our petition. Your Lordship, I invite you to look at paragraph 37 of the same decision, paragraph 39 of the decision, 40, 41, and 42. And most importantly, on the standard of proof. Your Lordship, it's my humble submission that when the Senate or the National Assembly sit as a quasi-judicial organ, whatever submissions or contributions members of the Senate or the National Assembly contribute to must speak to the fact in issue, because it's sitting as a tribunal. That is to say, therefore, Your Lordship, the message coming from the floor of the assemblies must speak to the motion. It must speak to substantiating the motion. But Your Lordship, when you look at the various members, how they contributed to the motion that was before the assembly, and Your Lordship, I would wish to begin by looking at what transpired in the National Assembly. The same evidence finds itself at the Nyengenye's affidavit. Look at what Honorable Ibrahim Sane said. This is what he said, I'll quote. I want to bring out 3 assertions which are highly distorted, emanating from His Excellency the Deputy President Gachagua. The second thing is that one who calls himself a co-president. So this member of parliament who voted for the motion was aggrieved by mere perceptions. He says, the second thing is that he always talks of having acquired a paramilitary training. He is supposed to be a symbol of harmony. So how did the issues of paramilitary, were they part and parcel of what was being considered? Even if, Your Lordship, you are to look at the Evidence Act, Section 5, as well as Section 35, on the relevance of evidence and its admissibility, Your Lordship, does this member of parliament speak to the motion? He's aggrieved that His Excellency considers and says that he has acquired paramilitary training. Look at what Ali Rosa says, member for SACU, UDA. The national unity is one of the reasons the deputy president must be impeached. He came into public stage to talk about an issue that eventually would undermine, discriminate the minorities. What issue was he speaking about? He was addressing the issues of one man, one vote, 1 shilling. This member is aggrieved by an issue that was out in the public domain. The country was seriously engaged even during the time of the BBI with the argument of 1 man, 1 shilling, 1 vote. For that reason, he votes to impeach the deputy president. The relevance, Your Lordship, the relevance of evidence. The nexus between what transpired in the Senate and in the National Assembly to the motion in issue. The nexus. Your Lordship, let me just look at what Honorable Elijah Kororia says, member for Gatondo North. The rest you read, my lords. I want to remind this House that during the swearing-in ceremony at Moi International Sports Center, Kasarani, he humiliated Honorable Uhuru Muigai Kenyatta so badly before the nation and visiting dignitaries in the Republic of Kenya. This member of parliament for Gatondo did not make any further submissions on the motion. He was aggrieved by issues that were irrelevant, irrational, unreasonable. How was there any particulars in the motion that spoke about the conduct of the deputy president during the swearing in? Again, look at Honorable Kagombe, member for Gatondo South. Again, he speaks irrelevant issues, Your Lordship. What am I saying? Again, you also look at what the member, the women rep for Nyandarua said. She was aggrieved, Honorable Faith Gitau, that the deputy president has no respect for women. The reading of the motion, Your Lordship, I did not see any charge that invited the National Assembly or the Senate to evaluate such kind of conduct. There was no particulars and there was no charge. That is to say, Your Lordship, again, allow me to take you to the Senate and look at what Senator Tabitha Keroche says. This is what he says. If the boss decides that he does not want an employee, what can you do about it? It tells Your Lordship, this was a predisposition and a prejudged outcome. And you see, Your Lordship, when seated at the Senate, each senator sits as undistinguished and distinct jury. So this jury, Your Lordship, when he makes this kind of perceptions, political perceptions, they have the capacity and the possibility of persuading other members of the Senate. Because each vote of the member of the Senate is cast as an individual vote. So, Your Lordship, then you want to ask yourself, look at what my learned friend, Senior Counsel Ogenda is aggrieved by. Again, we shall quote him. We'll have no... So Sifuna said that, Sifuna says that he has looked at the motion. He has found that the motion does not fit well in law. But what does he do? At the fullness of time, he votes for the motion. He impeaches. You need to distinguish the conduct between Tabitha Keroche and Honorable Sifuna. Keroche is a layman or a woman. Sifuna is an advocate of this court. But even in the absence of evidence, in the absence of law supporting the process, Sifuna impeaches. Even after making a valid observation that this motion is not worth the paper it's written on. But he impeaches. It tells Your Lordship that what was happening there was not an impeachment. The Senate and the National Assembly was not in pursuit of good governance. It was not in pursuit of transparency. It was not in pursuit of accountability. It was not in pursuit of the rule of law. It was in pursuit of political elimination. That is what guided the Senate. And Your Lordship, then you might want to ask yourself, Whether such a motion, Your Lordship, the nexus between the contribution of the members of the Senate and the motion. Wambora 21 says that there must be a nexus. And not just the nexus between above the contribution, but even the particulars that are alleged to have been transgressed and the person facing the impeachment. Your Lordship, again I remind you that in 1966, during the Uganda crisis, when Milton Obote, the then Prime Minister, decided to dislodge Edward Kabaka Mutesa II, there was a minister called Grace Ibingira. He was a minister of constitutional affairs. And during that time, there used to exist the deportation of undesirable characters ordinance. That is, you find it in our law reports, East Africa law report. So the ordinance was being used by Kabaka and the protectorate then to deport undesired characters to the harsh Karamoja region. Then came in Obote, and Obote proposed, let us repeal this law. Ibingira, being the Minister for Constitutional Affairs, objected to the repealing of that law because he thought that that law would be used to serve the enemies that would be perceived. Do you know what, Your Lordship? Ibingira was the first person who was deported under that law to Karamoja region. That draws a lesson, Your Lordship, for us all. That this impeachment is not about His Excellency Rigathi Gachagua. Again, I confirm, it's about the posterity of our nation. Your Lordship, when it was argued that His Excellency has been taken ill, my submission, Your Lordship, is that Article 19, Article 21, Article 20, Article 24, Article 25, Article 27, and Article 28 kicked in. We are no longer now looking at the expediency of the impeachment, but looking at the right of that particular individual, the right to life, right to equal protection before the law, right to the dignity. That is what we are looking at. The Senate ignored all those. But what does Wambora tell you? Wambora case tells you, look and see whether there was a violation of the rights. Your Lordship, our submission is that there was serious transgression of those rights. Your Lordship, permit me to draw your attention to section, as I go to my next point, Article 138 of the Constitution, Clause 2. It speaks about the procedure at the presidential elections. I will draw parallel later. If two or more candidates for the president are nominated, an election shall be held in each constituency. My interest is the word each constituency. When looking at this, Your Lordship, and having submitted earlier that the office of the deputy president are derivative of the office of the president, when the Nation Assembly was called upon to initiate public participation, they were supposed to initiate this public participation in the same manner and the same mode this particular person they're removing from office came into office. You reckon, Your Lordship, that in the case of Maina Kiai, it was decided that the election is at the polling center. That election at the polling center, Your Lordship, is the most minute space where the people can exercise their sovereignty. So if we are putting in a president and the deputy president at the polling station, how do you remove him at the county headquarters? How do you make relevance of the county headquarters being the forum for public participation? How did my mother in Karusho participate in the removal of the deputy president? Yet that removal affects her sovereign will. So, Your Lordship, I will draw you to an affidavit by my friend David Madenge. David Madenge is not just any other individual. David Munyi Madenge is a member of the County Assembly of Kirinyaga. He says at paragraph 9, paragraph 11, that he participated in that process. He has even annexed photos in that particular affidavit where individuals were blocked from accessing those so-called public participation forums. This is an elected member. His affidavit must be considered in the weight it deserves, having been a member who is already enjoying the sovereignty of the people. And again, Your Lordship, when you're looking at this affidavit, again look at the annexure marked as PP, as DMM1. This is the National Assembly announcement or notification of the extension of the public participation. They quote and rely on the decision of your brother, Justice Mwongo. Justice Mwongo, and that is the reason why my learned friend, the Member of Parliament for Kirinyaga, Honorable Njeri, referred to the notice of motion that brought forth these particular orders, was specific as to the forums where the public participation was to take place. The judge was therefore reading Article 138, Clause 2, that we must go as close as possible. We must decentralize as much as we can to ensure that there is meaningful, there is quantitative and qualitative public participation. But when you put it in a notice like this, my mother at Karusho, she hardly reads newspapers. She hardly reads newspapers. And Karusho, Your Lordship, is about 130 kilometers from where we are seated. We also have individuals from where we are seated in Banisa who are 700 kilometers from where we are. A newspaper is published. Tell me how Galo, how Muhammad, how Hassan had the ability to participate in this process. Just become pragmatic, my lords. View it in that lens. Your Lordship, as I sum up, permit me again to draw your attention to Article 50. Article 50, Clause 2, Paragraph H. Your Lordship, the Deputy President was unable to attend to his defense. Most importantly, Your Lordship, for this court to note, is that the Deputy President was the only witness for that case. He was not to call any other witness. And he has been denied an opportunity to defend himself. You'll hear my learned friend, Senior Counsel Tom Ojenda, telling you that Article 50, Clause 2, Paragraph H, permits such kind of a conduct. It says, Your Lordship, every accused person has a right to a fair trial, which includes the right, H, to be present when being tried, unless the conduct of the accused persons makes it impossible for the trial to proceed. I am very sure they would have relied on that, Your Lordship. Let me preempt them. Your Lordship, two things here. In Wambora's case, Wambora indicates, that is Wambora, the locus classicus, that the process of the impeachment is neither criminal nor civil. Therefore, this provision cannot be taken as an exemption to create the necessity for the Deputy President to be available during the process of the impeachment. Because it's distinguished that this specifically applies to an accused person. And Wambora has said that an impeachment is neither criminal nor civil. So there was no possibility, Your Lordship, that his presence could have been done away with. It was mandatory, Your Lordship, for the Deputy President to be present during the trial. As I sum up, Your Lordship, you might then ask yourself, in the circumstances, Your Lordship, where an individual has not been heard, where a person has pleaded his unavailability as a result of illness, what was available for the Senate to do? I sat through, I was present, Senior Counsel Paul Moite making an application for adjournment up to Tuesday. They rushed as if London was burning to deny that right. What was the reason, Your Lordship? They said that this was a time-bound process. That's a fallacy. That is a legal fallacy. This was not a time-bound process. And I look at it in two ways. If we were to say, Your Lordship, that the impeachment was to take place at the committee stage, there were 10 days provided for. If you were to say that the impeachment therefore was to take place as it did in the plenary, there were no rules requiring or giving the time period within which that process must be complete. May I repeat? When they opted for the plenary, and when they failed to modify this process so as to bring into conformity with the circumstances of the case and to create the necessary legal procedures for the impeachment, they went for it in a blanket manner, because the plenary itself did not prescribe the time period within which this impeachment must be completed. Your Lordship, to the extent that this Senate failed to grant the Deputy President an opportunity to defend himself and hid behind the timelines, which are not constitutionally provided for because they went for the plenary, then, Your Lordship, there was a transgression of Article 25, which provides for the non-derogable rights, and a transgression and a violation of Article 50. We cannot look at it in any other way. There were no rules. The Speaker did not guide the members of the Senate as to how the plenary was to proceed if it were to sit as a quasi-judicial process. Lordship, as I invite my learned friend, Mr. Nyamu, permit me, Your Lordship, to urge you to admit these petitions. I equally associate myself with the submissions made in petition by the first petitioner and all the petitioners who have submitted before. But again, look at the affidavit of Honorable Jerry Maina. Again, Honorable Jerry Maina is not any other person. She's an MP, a member of parliament, who sat all through in that parliament, who sat and contributed to that motion. When she tells you that in her constituency, there was no public participation, who am I to deny? Who am I not to believe her? She's elected. She has a distinct, identifiable constituency that her affidavit speaks about. Your Lordship, permit me to invite my learned friend, Mr. Nyamu, and urge you, Your Lordship, to find that there was no impeachment at all, and my Lord, to quash the said impeachment. But while quashing it, Your Lordship, again remember that there is nothing unjusticiable before you. The question of justiciability has been dealt with in the case of Wambora 21, and again, the case of unjusticiability, Your Lordship, that constitutional virginity was penetrated when Article 165, Clause 3, Paragraph D was enacted. That this court can penetrate the works of the Senate, the works of the National Assembly, to see to it whether it was done in accordance to the Constitution. It no longer enjoys that constitutional virginity. Mr. Nyamu. Thank you, Lordship.
Thank you.
Thank you, my lords and my lady. In the interest of justice and time, I do not need 10 minutes. I only need 4.5 minutes. My lords, my lady, my learned colleague, Gachagua, has submitted exhaustively. So, I will only be enumerating the reliefs sought. My lords and my lady, at the heart of this petition lies the doctrine of popular sovereignty, as codified under Article 1, which vests the sovereignty or the sovereign power in the people of Kenya and permits its exercise either directly or through the democratically elected representatives. My lords and my lady, the office of the Deputy President is not an appointed or technocratic office. It is a direct product of a universal suffrage, deriving its legitimacy from the will of the electorates expressed at the ballot. It therefore follows that any process that seeks to remove a deputy president from office must be approached with heightened constitutional sensitivity and restraint. It implicates not merely the tenure of an individual office holder, but the sovereign will of the people themselves. Therefore, as a result, and culminating from our submissions, we have sought the following reliefs. 1, a declaration that the impeachment proceedings against the Deputy President were conducted in violation of the Constitution of Kenya and were therefore unconstitutional, null and void. Number 2, a declaration that failure to apply the modification framework under Article 152, read together with Article 144 and 145, as required, rendered the entire impeachment process fatally defective. C, a declaration that the proceedings violated the petitioner's right under Article 52A, as well as 26, 28, 48 of the Constitution. D, a declaration that the Senate acted in breach of its own standing orders, including standing orders number 75, 78, and 80, thereby rendering the proceedings procedurally ultra-vires. E, an order of certiorari quashing the impeachment decision and all consequential actions arising therefrom. F, an order of prohibition restraining the implementation, enforcement, or further reliance upon the impugned impeachment decision. And lastly, any other consequential or auxiliary order that this Honorable Court may deem fit and just to grant. Thank you very much, my lords and my lady.
Thank you.
Your Honor, I had asked for 15 minutes. I'll try to maintain that. I acknowledge that I see I'm the last petitioner. It's based on, I believe the petitioners are really exhausted and have given admirable, so their submissions with admirable force and clarity that I feel like I'll only be doing closing remarks because they have almost said everything.
Please tell us your name.
I'm Momanyi for the 58th petition.
15th.
58th petition.
Yes.
Yeah, 58th.
They are not here.
Yes, Your Honor. Your Honor, we do rely on our petition, which is dated the 18th of October 2024 and amended on the 23rd of October 2024. Our submissions are also dated, our submissions and list of authorities dated the 2nd of January 2026. Your Honor, I'll seek not to traverse grounds that have already been submitted upon by my fellow petitioners. I'll only seek to maybe highlight or underscore cardinal aspects that I think maybe have not been mentioned or have not been given in the flavor that the petitioner herein may have wanted to do. Your Honor, we do submit that, looking even at our submissions, we submit that this impeachment does rest on one singular but profound constitutional question. And simply, this question, which relates to the issues that we put before this court, is whether the impeachment of the Deputy President, the former Deputy President Rigathi Gachagua, His Excellency Rigathi Gachagua, was conducted in accordance with the Constitution, or whether it represent, or whether that impeachment process only represents what we term as a fundamental misapplication of constitutional power. In our submissions, we submit that the impeachment process in its entirety is a definite misapplication on constitutional power. And when we speak to constitutional power, we do rest our arguments on Chapter 1 of the Constitution of Kenya. Article 1.1 of the Constitution of Kenya does state that sovereign power belongs to the people of Kenya and shall be exercised only in accordance with that Constitution. And when you read that provision, Article 1.1, we are reading it together with Article 1.3, which provides on how this sovereign is to be exercised through delegated power. And this delegated power has been delegated to the three arms of government. And in our submissions is that the parliament violated this power that has been given by the people. And we say that when delegated power, which the parliament wielded so capriciously for political convenience against the very people from whom that power was given, that exercise ceased to be constitutional governance and only descended to be constitutional betrayal. And you see a parliament that indeed betrayed the sovereign power that has been given by the people and conducted an impeachment process that is not only unfair, but also an impeachment process that gravely violates very many provisions of the Constitution. In our petition, we quoted 20 provisions of that Constitution. The petitioners that have come before me have listed a lot of those provisions. I wish not to repeat. But only in summarizing my arguments under Article 1.1, I seek to remind this court of the quote by Justice Emeritus Chief Justice Maraga, when he said that the greatness of any nation lies in its fidelity to the Constitution and adherence to the rule of law, and above all, respect to God. And we also submit that the only way to preserve the rule of law is to apply it equally to everyone. And many petitioners who have come before me, they have said that the impeachment process fell well below the standard of the Constitution. Your Honor, this impeachment process, as it is, opens a constitutional to power. It provides an alternative way in which the direct vote of the people has an alternative, whereby we can easily impeach a leader who has been validly elected by the people through such of a sham of an impeachment process. And we urge this court to shut this door, because this impeachment, the way it was done, it puts the country at a very bad position, and as it has only left a constitutional backdoor to power, which we submit should not be allowed, as it will be an alternative pathway to electoral process, which is the direct power of the people, which is provided under Article 1. On fair hearing, Article 50, I wish not to dwell on this because the petitioners before me have really exhausted this ground. But I wish maybe to remind, I remember when my senior, Mr. Ongoya, was presenting his submissions before you, he listed 3 trials that he termed as predetermined trials with unfair outcome. I do not know the 2, but I know at least the trial of Jesus Christ. And I say in my humble submission that at least with the trial of Jesus Christ, Jesus was given the opportunity to be heard. In this impeachment process, it really, when you look at it, and you look in a constitutional democracy of the 21st century, such as Kenya, with a constitution that is celebrated across the globe, with a constitution that has fidelity to human rights and due process, you can really make a conclusion that this parliament sank very low. Even when you look even at the conduct of the speakers of both parliament, and I also relate it to the trial of Jesus, I say that at least the Pontius Pilate washed his hands when he saw that people could not move. But when you look at the Senate, instead of calling the House to order, they prevailed even to vote. Like the Speaker of the Senate went ahead to put a vote on whether someone's constitutional rights of a fair hearing should be respected. Your Honor, Article 50 contains rights that are not only inalienable, but also non-derogable. And that was a great violation of the Constitution. Your Honor, I seek to move to Article 145 and 150. And the petitioners who have come before me have made arguments both on the threshold and the process. And they have submitted that this process failed in both, not only in process, but also in threshold that is required by the Constitution. When you look at process, and I submit on Article 145(3), they made very many distinct legal arguments on whether it is a discretion or the Constitution requires that there must be a special committee. Your Honor, I'll only argue on English, plain English, even literal rule in interpretation of that provision. Your Honor, when you use the word may and you add and, you remove it as an option. When you say, for instance, may I see John and James, it is either you see John and James or you don't. And I submit that that may that has been put there is only functions whereby the Senate may not proceed to impeachment. There might even be a preliminary objection, notice of objection on the floor of Parliament, maybe something that has emanated from the National Assembly that prevents even the Senate itself from proceeding to impeachment. But we submit that as per Article 145 and 150, there must be a special committee for investigations. On the aspect of threshold, the Constitution is very clear. It uses the word serious, it uses the word gross. Your Honor, these words are not ornamental. They have a purpose. The framers of the Constitution put them there for a particular purpose. And by use of those terms, it means that there are offenses that are impeachable, and there are also other offenses that are not impeachable. And as such, we submit that none of those charges met the threshold. And I'd like to maybe dwell on the common ground, the issue of shareholder. When you look at the mover of that motion, there's nothing he presented apart from the argument that when the Deputy President was talking about shareholder, those words were divisive, those words were inciting the public. No other evidence was brought in Parliament. Your Honor, what this mover wanted is that he put himself out as an authority to tell the parliament, both houses of parliament, that the term shareholder is inciting, the term shareholder is divisive, the term shareholder is against the National Cohesion and Integration Act, without even the institutional backing of that body, which enjoys public money, taxpayers' money, for it to act. Even the Senate did not proceed to conduct investigation so that they can establish these words divisive, as the National Cohesion and Integration Commission deemed it as insightful and divisive. We submit that it lacked authoritative and institutional support. So it was just the words of the mover of impeachment. I believe we dwell on the Latin phrase of ipsi dixit, which simply refers to somebody, a speaker, simply telling people that, believe me, I'm the authority. This is what I mean when I say that these words are divisive and insightful. On Article 152.
Council, you're in your last 2 minutes?
Yes, I'm finalizing. Yes, a minute.
Minute and a half.
Yes, Your Honor. Yes, my lady. Your Honor, as I finish on Article 152, the petitioners who have come before me have made valid arguments on that provision. I seek not to go deep into the legal aspects of it. I only seek to direct this, my lords and my lady, to the Senate Hansard on the 17th of October 2024. I see Mr. Ojenda has been, Professor Ojenda has been attacking petitioners for mentioning Sifuna. Let me make a change and mention Okia Omtata. And Mr. Okia Omtata, these words, even if these words are adequate to prove that this provision was violated. He says that I stand here to look at whether the House has complied with the Constitution, and he mentions Article 152 on removal of the Deputy President from office. And he makes similar submissions to what my senior, Mr. Ndego, has made, that the role of a Deputy President is derivative. So when you move to impeach a Deputy President, you must acknowledge that aspect. And he says that these modifications have been couched as a mandatory. So when you're making impeachment of a Deputy President, you must do the necessary modifications. Your Honor, I will not proceed to, I will rest at this position. My prayers are similar to what other petitioners have prayed for because of time. I'll not proceed to mention and rest my submissions at this position. Thank you very much.
Thank you very much. We have come to who are you? Oh? How much time do you want? Okay.
So I will use 5 minutes and allow my colleague to use 5 minutes.
All right.
5 minutes, it's now 2:30, so 2:35.
Just before I start, I just wanted to mention that we have filed our trial bundle dated 15th of April on behalf of Kitusa Sheria, and also our submissions unserved.
Your name again?
My name is Mosongo Maosa. I appear alongside Margaret Awor. Can I start? Okay. Your Lordships and your Ladyship, our Constitution contains very many promises. I'll just highlight 5 promises. One of it is the promise of constitutional supremacy, that Kenyans, in exercise of their sovereign power, determined in Article 1 and 2 that sovereign power will only be exercised in accordance with the Constitution. And secondly, that the Constitution will remain supreme and at all times be followed by all organs. They were not fake promises, and Kenyans made these promises because they intended to keep every part of it. What you're arguing is that in this process, the respondents did not honor this promise that the Constitution is supreme and must be followed. Secondly, we want to argue that there was a promise that through all processes of governance, there will be transparency and public involvement. In Article 10 and 118, Kenyans had the good intentions to ensure that the promise that in all processes, the public participation of the people will be inculcated. That promise, they intended to keep it. And we are arguing that the respondents did not safeguard this promise. The third is that there is a promise of fair trial and administrative actions. A promise means everything, and once it is broken, sorry means nothing. The first petitioner had been promised by Kenyans that he will be entitled to a fair trial and a fair administrative action. Your Lordship and your Ladyship, broken promises are the reason why some people are scared to trust again, and that's why if I've asked for 5 minutes and I take more 1 minute, you wouldn't trust me again. So the same way, if Kenyans had indicated that the first petitioner would have the right to ask for an adjournment, to be present and appear, and be able to defend his case, and that right is taken away, it is unfair, and some promises can break your heart too. And in this case, he actually ended up in hospital. That this promise that had been, that he will be entitled to public participation before his removal was not safeguarded, that the processes relating to his removal would be fair, and it was not fair, he ended up sick. And we are saying that in the same manner, we urge this court to safeguard this promise of a fair trial and administrative action. I still have 1.5 minutes. The fourth promise is that our Constitution, in Article 104, 145, 150, 152, 168, gives the promise of fair removal for state officers. It's not only the Deputy President who is required to be removed in a fair process, but also members of Parliament in Article 104, there's the right to recall our learned senior Professor Tom Ogenda. If the people of Kisumu so wish to recall him, they can recall him, but the Constitution requires that that process must be fair. Even the current president, His Excellency William Ruto, if he has to be removed, the process must be fair. And because we are now setting precedent on how they will be removed, we urge this court that the process and the promise that was given to the Deputy President was not safeguarded. There is no greater fraud than a promise not kept. We urge this court that, as Article 165 states that this Honorable Court has the power to intervene, and now that my 5 minutes are over, we urge your Lordships and your Ladyship that this promise of judicial protection of this process be safeguarded, that in as much as Parliament did not keep their promise, that this process ultimately, the judicial scrutiny, will also be kept. Thank you. I allow Margaret to do the remaining 5 minutes. Thank you, Your Lordships.
Thank you for keeping your promise.
Thank you, my lordships and my lady. Much has been said about public participation, but what I'll hammer home is the public participation that was conducted by the respondents. The National Assembly did not meet the thresholds of Article 10 and Article 118 of the Constitution of Kenya 2010. The Constitution of Kenya, Article 10 and 118 of the Constitution of Kenya provides that the public participation that should be accorded is one that is reasonable and one that is meaningful. The one that was provided by the National Assembly did not meet these thresholds. Why do I say so? If you look at the public participation that was conducted, it was condensed to 47 hubs, which was conducted in a hurry. Let's take Nakuru SK Showground. It encompassed citizens from Molo, Njoro, Naivasha, Gilgil, Kuresoi South, Kuresoi North, Subukia, Rongai, Bahati, Nakuru, Nakuru Town West, and Nakuru Town East. My lords, my lady, this required citizens to travel from far places to one single center, that what they were going to do was to vote, a chat box voting, not an engagement. That did not meet the thresholds of Article 10 and Article 118. Your Honor, sorry, my lords, my lady, you have the mandate or the power to intervene when procedure is not followed, when the procedure that is provided for under the Constitution is not followed. This power is provided for under Article 165(3) of the Constitution, and also as it was hammered in the Wambora case, the Court of Appeal, that you may only come into where necessary to confirm that the process has been properly followed as laid down in the Constitution. We are not inviting this court to intervene or to rewrite politics, but to enforce and preserve the Constitution of Kenya and the rule of law. Our prayers are provided for under paragraph 27 of our replying affidavit. These are our prayers. A declaration that the public participation undertaken by the first and the second respondent in the impeachment process of the first petitioner was neither quantitative nor qualitative as required by the Constitution. A declaration that the notice for public participation issued by the first and the second respondents were inadequate, the time frame provided for was insufficient, and the participatory mechanisms utilized were limited. To declare that the impeachment process failed to meet the constitutional threshold of public participation and is therefore constitutionally defective. Declare that the impeachment proceedings conducted on the 16th day of October 2024 by the third and the fourth respondent were procedurally unfair, unconstitutional, and ultra-vires. Declare that the third and the fourth respondents, acting quasi-judicial, violated Article 47 and 50 of the Constitution of Kenya 2010 by denying cross-examination, re-examination, and a reasonable adjournment. A word, of course, to the seventh interested party who is Kituo cha Sheria. I humbly submit.
What is the date of your affidavit and who has deponed to it?
15th April